The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Well, good morning, everybody. Please be seated. Welcome to the United States Court of Appeals for the Fourth Circuit. We have 4 cases on for argument this morning. The first is 24-1970, Stanley versus Bocock or Bocock. Someone will correct me if I butchered that. Mr. Grimes?
Yes, Your Honor. And may it please the court, and it is Bocock, Your Honor, that is correct. The issue in this case is whether the probable cause finding in the search warrants is a bar as a matter of law to the retaliatory search warrant claim. The answer under Gonzalez and the Nieves carve-out is it is not. There are 4 reasons why the district court decision must be reversed. First, under Gonzalez, if it was not clear before, it's clear now that probable cause is not a silver bullet to these First Amendment retaliatory claims. There is no requirement, particularly when objective evidence exists, to plead and prove an absence of probable cause. And for this reason alone, the district court's decision must be reversed. Objective evidence is the only requirement for retaliatory claims, and here we have clear objective evidence. I also commend to you, and I filed a notice of supplemental authority yesterday, Judge Ho's dissenting opinion in the Fifth Circuit's decision denying the petition for rehearing, which is Gonzalez versus Trevino, 60 F4 906. And there Judge Ho stated that the absence of probable cause is not necessary to sustain a First Amendment retaliatory arrest claim. And Judge Ho emphasized the importance of the First Amendment in that case, and quoting Lawrence Silberman said that the First Amendment's guarantee of free speech is not just a legal doctrine, it represents the most fundamental value in American democracy. A national commitment to uninhibited political speech is a crucial aspect of the country's culture.
Mr. Grimes?
Yes.
Are you conceding that there was probable cause and moving on to why that doesn't matter in this case? Or what?
No.
Okay.
No.
So what's your argument for why there wasn't probable cause?
Our argument with respect to what, first of all, it's not central to our argument that there is no probable cause. With particular respect to retaliatory search warrant case, you assume probable cause because a magistrate has issued a warrant finding probable cause. But our argument with respect to that point, Judge Diaz, and that's my 4th point, is that this search warrant, these 2 search warrants, were issued by a magistrate judge in Virginia. And in our view, which does not have to be a lawyer in Virginia, I don't know whether you're aware of that or not, a magistrate judge in Virginia is not like a magistrate judge in federal court.
I'm not sure that we make those kinds of distinctions in the law, right? So why does that matter?
I'm not sure that it does. I simply note it. I simply note it.
Well, you're noting it for a reason, I guess, because you think it matters, but it doesn't.
Well, I agree with you that it doesn't matter. So I disregard what I've just said with respect to that particular point. But the question is, why is there no probable cause? And in our view, any magistrate worth his salt who with the First Amendment firmly in mind, who had read that affidavit and seen what it says, and what it says is that part of the reason that this search warrants are being issued, incidentally, this is a novel case as best I can tell, and Judge Dillon found that below. This issue is novel with respect to retaliatory search warrants. But Bocock's own admission, Joe Stanley has made several posts showing his disdain, that's the word, his disdain for the government and the Rocky Mount Police Department. This is
but why do we think that's retaliatory as opposed to like the showing of malice that's sort of required to violate this statute, right? That you can't accidentally do it, right? So they're trying to show that this is like an intentional action. Like they didn't go in and like stumble across the video, but he's doing this with purpose, with intent. And so I read that as like helping to establish probable cause, not undermining it in any way.
Well, I submit that people could view that differently, Judge Richardson, and bear
Oh, but you understand, if people could view that differently, then we're gonna defer to the magistrate judge, right? Who was on the ground, who was able to make that decision. I fully agree. You might want to read it your way. I don't frankly read it that way, but that's plausible, maybe. But we've got a magistrate judge who's a neutral decision maker who read it to establish probable cause. And one of the things you've got to show is a mens rea. And that evidence, like, plainly goes to the mens rea with respect to the videos.
Let's assume probable cause then. Let's assume probable cause, because it's not essential to your finding here. But I take your point, well taken. But let's just assume there is probable cause. We still have objective evidence. The word disdain, in my view, can only be read one way, but you may read it a different way, and I get that. But we have Bocock's own admissions that we're doing this because Joe Stanley has made posts on Facebook expressing disdain for the town of Rocky Mount Police Department and the government. In our view, this is quintessential objective evidence, but we have a second piece. The police department here did not search its own computers for evidence of any crime. They did not search their own computers to see whether they were used to access or harvest or send the video. Discovery is required to determine exactly what
So help me understand, under the narrow exception that we talk about under Nevis, is that you were arrested when other similarly situated individuals were not, right? None of this goes to that question. That's the narrow exception that exists in those cases. What's irrelevant, the court seems to say quite clearly, is even objective evidence showing that the officer was motivated by comments showing disdain. That doesn't have it. That's what Nevis says is irrelevant. What you need is objective evidence. This is what Gonzalez gets at too, is that there are other people, other similarly situated folks were not getting arrested, and you were. Or in this instance, were getting searched or not getting searched, and you were. The type of evidence you're talking about under this narrow exception seems like fundamentally mistaken. Help me understand why I'm misunderstanding you.
That's exactly why Gonzalez was reversed, Your Honor. There wasn't.
No, but Gonzalez was reversed because you don't have to show a comparator.
Right.
But it obviously focused on this same question that you were arrested in that instance when others were not, right? And so what the court said there is the fact that there was nobody else arrested for this offense suffices. You don't need a comparator. That's what Gonzalez tells us. That makes total sense to me. But it doesn't say that we're now looking at objective evidence of the subjective motivations of a given officer. That's precisely what the court rejected. Like that, you seem like to have this case exactly backwards.
Well, I would disagree, and as I read Gonzalez, there was no objective evidence in that case.
The objective evidence there was that nobody else had been arrested for that offense. That's what the objective evidence was.
But you have to look at what Sylvia and Gonzalez...
But that is objective evidence, right? You agree that's objective evidence?
That would be objective evidence.
And that is objective evidence that similarly situated people were not being arrested in the manner in which that individual was.
In that case, what Sylvia Gonzalez did is, allegedly, is she got elected to city council. She circulated a petition to remove the administrator, and during some meeting, allegedly, the petition wound up among her papers as she left the town hall. That's why she was arrested there, and so that was sui generis, and the Supreme Court said that in that case, she did not have to show any comparator evidence. They did not reach the second question, the question I have posed here to you, which is raised by Judge Ho in his opinion below in Gonzalez, and which is the novel question recognized by Judge Dillon, and that is whether a plaintiff must plead and prove the absence of probable cause in a case such as this, a retaliatory search warrant case. I've only found...
Were there motions made to quash the search warrants for lack of probable cause?
Yes.
And that were litigated and were denied, and they went to appellate courts in Virginia
Yes.
and were upheld.
That's why we're here, is upheld.
What's the effect of these rulings by the Virginia appeals courts?
The effect of those rulings is to show that the plaintiff had no relief in state court because there was no criminal action pending. She could not, Mr. Stanley could not suppress the search warrants there because there's no criminal action pending. His only relief is via 1983 in the Fourth Amendment and the First Amendment in district court. That's his only relief. That's the outcome of what happened there. There was no criminal prosecution here. As you've noted, Judge King, the specially appointed neighboring prosecuting attorney Brian Haskins in Pittsylvania County, which is one county east of Franklin County, said that there's no crime here. There's no malice. There's insufficient evidence of malice. And he had the very document that you've referred to, Judge Richardson, and this is what Brian Haskins said. I'm of the opinion there is not...
You don't think that you're prohibited from getting a search warrant, or that we find a search warrant to be invalid because a prosecutor later, in the exercise of their broad prosecutorial discretion, decides not to bring a charge based on the evidence that is uncovered by the search warrant, right? I mean, that kind of hindsight is not like useful at all, it strikes me, right? That might, Haskins might have done exactly the right thing. He had broad prosecutorial authority. But that doesn't mean that his decision to not prosecute because he did not think there was sufficient evidence to convict tells us anything about whether there was probable cause for the search warrant, right?
Point well taken. Point well taken with respect to Haskins' decision not to prosecute or finding that there's no probable cause to prosecute. Understood. But I still think that here that we have the type of objective evidence. Now, you are reading the word disdain to support motive. To support motive under the criminal trespass statute, which is not far removed, I think, from your jaywalking cases, and that term comes up in a lot of these cases. People are
Because jaywalking requires like a malicious motive.
no. It's that it's something that's committed every day by people and is not prosecuted. And
so computer hacking, just your point is that computer hacking is committed every day, and so I guess I'm not sure I'm following.
Where is the evidence? There's no evidence of computer trespass. There's no evidence. They ask you to infer that a computer was used to harvest, but there's no evidence of that. It could be very easy simply...
You think they got it off of a Betamax tape? Like, you think they broke in and took a Betamax? Like, where do they think they got the video from, if not a computer? I mean,
Where do they think they got...
Where do you think it came from? You're saying there's no evidence that it was a computer. Like, where do you think... I mean, have you seen a video on a Betamax recently? Like, when's the last time you saw security camera footage that wasn't stored on a computer?
It could be a SIMS card that you simply remove from a camera you're on. But this is why discovery is required. Discovery is required to determine how that was accessed.
I'm not sure why that would be necessary, assuming that makes sense, that there are other logical possibilities. This is a question of probable cause, right? And the fact that the officers started their investigation by looking at your client's computer. Among the other possibilities, Betamax, you may be dating yourself, I think VHS came after Betamax, but...
It was intentional.
But this is not a question of there was a certainty that this evidence would be found there. It's just one among many possibilities. So what is wrong with the investigating officer beginning with the computer?
I think the investigating officer should have begun with the computer, but should not have looked at Joseph Stanley's computer. They didn't look at Joseph. They seized his Facebook and Google accounts, but the same thing, I suppose, looking at evidence generated from a computer. But they should have looked at their own computers, in our view. The fact they didn't, in our view, is objective evidence. They did not want...
What's the best case that you have that says probable cause is lacking when a defense lawyer thinks of a better investigative technique?
A better investigative technique?
When you think there was something better that could have been done, have you ever seen a case where we invalidated a police officer's search warrant because after the fact you hypothesize a better investigative technique?
No. I've never seen a case like this one. I've never seen a case where a search warrant says that so-and-so has expressed disdain for the government, therefore we're issuing the search warrant to seize all of his Facebook accounts and Google accounts, which were, just as in Gonzalez, was for the specific purpose of chilling his exercise of free speech. Just as in Gonzalez. Sylvia Gonzalez wrote, "I will never again run for public office because of what they did to me when I circulated that petition." That's the whole goal here. It's First Amendment chilling. That's the goal of the government in this case, and it worked. It worked. It's quieted Joe Stanley as well. So it served its purpose. Now, you could say, Judge Richardson, well, that supports the malice component, which was, in my view, invalidated by Brian Haskins, the prosecutor. But it could also be that we're going after this material because Joe Stanley has expressed disdain for the government. That's why we're seizing his Facebook and Google accounts. I see that my time is up. I've reserved 5 minutes. I'll address any additional questions on rebuttal.
Thank you, Mr. Grimes. Mr. Bryant?
Of course.
Good morning, and may it please the court. I'm Graham Bryant, Principal Deputy Solicitor General of Virginia, on behalf of Officer Bocock, Special Agent Bocock. With me at council table is Deputy Solicitor General Meredith Baker. After Joseph Stanley posted to his Facebook page video footage that was unlawfully taken from a police department surveillance system, neutral magistrates to whom courts defer in probable cause determinations made the common sense determination that there would be a reasonable chance that evidence investigating the crime of computer trespass would be found on a search of his Facebook and Google accounts. That probable cause resolves this case. It's well established that the existence of probable cause defeats a Fourth Amendment unreasonable search claim. And the United States...
Don't you mean to also include the caveat from Gonzalez and Nieves that there's an exception to that? I mean, that's a general rule, but you're not trying to suggest that that exception doesn't apply or is not potentially applicable.
Of course, in First Amendment retaliatory claims, absolutely the Supreme Court has held in Nieves and Gonzalez that there is this narrow exception for objective evidence.
But can you help us understand, I think your colleague and I have different understandings of it, but from your perspective, can you help us understand what that means when they say objective evidence? What is the standard? What type of evidence is required? Objective evidence of what?
It's objective evidence that in the retaliatory arrest context, which critically is the only context where the Supreme Court has ever applied this exception, that the particular person bringing the retaliation claim was arrested and thus retaliated against in a context where police have not arrested other individuals. Gonzalez makes clear that unlike the Fifth Circuit's holding below in Gonzalez, you don't need someone by name, birthday, and social security number. You don't need specific, ascertainable comparators. What you do need is some form of objective evidence suggesting that other people in that situation, maybe not specific comparators, but a class of comparators, like the survey in Gonzalez that showed that there, the Texas statute had never been applied for a misplaced government record. It was always for things like falsifying IDs or cheating on a government exam. Never the type of thing where it was used against Ms. Gonzalez.
So this case was dismissed at what stage, 12B6?
12B6, yes, Judge.
So how is a plaintiff supposed to get that evidence if he or she can't get discovery?
I think Gonzalez is instructive there. There, I believe she either obtained an affidavit or conducted research on, for that county, how many times has this statute been used and how has it been used? Publicly available information, and alleged that. That was part of the affirmative allegations. Discovery is not necessary to get this type of broad objective evidence. And I think when we look here at the type of objective evidence that Mr. Stanley is purporting to talk about here, the sole objective evidence he points to is the line in the search warrants about disdain for government, which goes to the malice element. I believe he mentioned that...
I'm sorry to interrupt, but, Gonzalez and Nieves, I think, were both talking about retaliatory arrest, is that same kind of public evidence available with respect to searches?
I think it'll depend on the facts of the particular type of claim at issue. Different types of arrests have different contexts. I mean, for instance, in Lozman, that was an official policy kind of situation. The court made a much narrower rule or a different rule than it did in a more typical case like Nieves and then in Gonzalez. So for these sorts of cases, you need to look at the specific facts that are there, and it's hard to make a broad statement about what kinds of objective evidence will be there. But I think the point that retaliatory search warrant claims are distinct in kind from retaliatory arrest claims is critical here. The Supreme Court never applied this sort of Nieves exception in the retaliatory prosecution context. And retaliatory prosecution is a bit more akin to what we have here in a retaliatory search warrant context. In both contexts, there is a government actor other than the officer who's the defendant in these cases that provides a check. For the prosecutor in retaliatory prosecution claims, we have the presumption of regularity for a prosecutor. For here, we have magistrate judges to whom courts owe deference in probable cause determinations. And it's well established that line police officers...
Are you suggesting that this Nieves-Gonzalez carve-out should not apply because we've got this sort of double layer, right? Officer and magistrate, the same way we might have officer and prosecutor? Or like what? I mean, I understand that argument. I didn't understand you to be making that argument. You might be. That's what I'm trying to get at. Do you think the Nieves exception for objective evidence that others are not arrested or for that type of action does not apply in the search warrant context?
I think it's not at all clear from the case law we have out there that it would, and it should...
I'm asking what your position is. I understand it is not clear from the case law. What I'm asking is, what is, the Commonwealth's position on whether this exception applies when we have this double layer, right? Both in the prosecution and in the search warrant context.
Yes, the Nieves exception does not apply in this context. That's been our affirmative argument on brief, given how different in kind this situation is from the retaliatory arrest context, which is the only context where the Supreme Court has ever identified that sort of exception.
I'm sorry, go ahead.
So in other words, it's sort of like Hartman, right?
Exactly.
And so Nieves carves out an exception to Hartman because there's a single layer of process. But where we've got a double layer, officer, prosecutor, officer, magistrate, that this sort of exception, the Nieves exception, simply doesn't apply at all.
Yes, Judge Richardson, that's certainly the view.
Sorry to interrupt again, but we don't need to decide that in this case if we agree with you that there simply is no evidence of a sufficient comparator to even consider that issue. Right?
Absolutely, Judge Diaz. Even assuming without deciding that such an exception would apply here, there's just no evidence. As the judge below pointed out, Mr. Stanley never even invoked this exception in his complaint. He didn't try to invoke it. He points only to the disdain comment in the search warrants, which goes to malice. He did argue here that the police did not search the police computer. And that's simply not an allegation in the complaint. That's an argument that exceeds the allegations in the complaint. As the district judge pointed out in the motion to dismiss opinion, the complaint says only that the police could have searched that computer. Not that they did, not that they did not. And an argument certainly can't exceed that. That leaves really the only objective evidence argument here, the statement that's in the warrants.
Why do you fight? I understand that. Why do you care about that? Why do you choose to raise that? Because I don't understand how that could possibly be relevant, right? The fact that you didn't take some investigative step, but you did take this one, I understand you want to fight on everything, but why does that possibly matter? If I'm trying to think about the case and what matters, why does it possibly matter whether you did or did not search the government computer?
It does not, because there's nothing that says that police must investigate in a particular way. But even if the court were to consider that, it's just simply not enough. So no matter what the court decides on the Nieves exception, it fails here, whether the exception does not apply at all in this context, which I believe is the correct threshold ruling, or that in this specific case, there simply aren't sufficient allegations to meet that objective exception. And more broadly, the notion that probable cause does in fact defeat a retaliatory search warrant claim, I think follows cleanly from the Supreme Court's precedents in this area, and Hartman in malicious prosecution, and then in Nieves and Gonzalez for retaliatory arrest. For all of those cases, there is
Either Nieves or Gonzalez sort of really rely upon this single layer versus the multi-layer review to create this exception. I mean, I understand you could read this into those cases, but what in either Gonzalez or Nieves would you point me to suggest that the Nieves exception is limited to cases that don't involve double layers?
I would point the court to the fact that certainly the Supreme Court has never extended it to any other context than retaliatory arrest. And retaliatory arrest simply presents unique circumstances that aren't present in others.
I understand all that, but what I'm asking, is there anything in those cases, in the language of those cases, not the implication of those cases, but is there anything in the language that suggests that Nieves' exception really turns on single versus double layer, as opposed to sort of trying to read that between the lines, I guess is what I'm really asking.
Certainly, there's no obvious objective statement that this only applies in this context. I think that's very true. But of course, the Supreme Court, like all appellate courts, typically doesn't decide more than it needs to decide in a given context. So I'm not sure that we would expect to see a statement like that either if the court did intend to so limit it.
Can I ask you a question about the sort of the atmospherics of this case? You know, Mr. Stanley obviously had a lot of concerns about the workings of his small-town government, and it wasn't isolated to the police department. It appears he had a broad range of grievances, and I'm not opining on whether or not they were legitimate, but, you know, that kind of forms the backdrop to this whole issue regarding the search and Mr. Grimes' complaint in this case that Mr. Stanley was singled out for action by the local police because of who he was and what he did and that. So it's different than a case where, just as an example, you've got a teenager who might have infiltrated might have posted the video and then he files a complaint and there's just no evidence of any retaliatory motive in that context. But here you've got at least this atmospheric of Mr. Stanley being a gadfly or pain in the rear end, for lack of a better description. He would say he's exercising vigorously his rights as a citizen. Is that enough to suggest that the case should go forward, just the background atmospherics?
Not at all, Judge Diaz. I think really across the board in these First Amendment retaliation cases, most of them do involve a situation where you have a community activist, someone who is actively and correctly exercising their First Amendment rights, but then also you'll have the competing influence of a genuine criminal investigation. And that's why the common thread throughout all of these First Amendment retaliation cases that touch in the criminal context is this intractable causation problem, which is what the Supreme Court has consistently pointed to the need for this no probable cause element. For these sorts of cases, you have to show that retaliatory animus didn't simply exist, but was the but-for cause of the challenged government action. But in the criminal context, protected First Amendment speech, as the court has recognized, is often a legitimate consideration in developing a criminal case and doing a criminal investigation. So then you have the question.
Do you read the line in the search warrant? Let me just rephrase it. How do you read the line, and what relevance do you ascribe to the line that he had ill will against the city? Why was that included in the search warrant? What was its relevance to the search warrant?
Judge Richardson, that goes directly to an element of the Virginia crime, 18.2.152.4, which the first lines of that statute are, it is unlawful for any person with malicious intent to go on and complete the other elements of a criminal computer trespass. So that malicious intent is an affirmative element. And here, the police are investigating to figure out who took this video from a police computer system and how it ultimately ended up on Stanley's Facebook page. It's no sign that they were ever investigating Stanley as the person who snuck into the police department and took it. What we have is a definite endpoint. This video was posted on a page, and the fact that that page belonged to someone who was known to be vocal in comments suggests, or at least leads the reasonable inference at the probable cause stage, that the person who shared it with him did so with the design that it wouldn't be hidden under a bushel, but instead shared publicly and detrimentally to the police department. that establishes the malice element at the probable cause standard, certainly. And that's the reason this line appears in both of the search warrants. The reason the probable cause evidence is so valuable in these First Amendment retaliation claims in the criminal context is that, as the court has recognized, probable cause provides a distinct body of evidence. It's going to exist in all of these criminal context cases, whether it's prosecution, arrest, or here, search warrant, that will tend to show, was this purely retaliation as the but-for cause, or was this an actual legitimate government investigation? And if probable cause exists, that shows that regardless of the animus, the challenged government action would have taken place anyway. But if there's no probable cause, that's highly suggestive that the action was taken specifically to retaliate and thus was the but-for cause. And then here, I think at the fairly deferential probable cause stage, both magistrates, two separate distinct magistrates, this just wasn't a single magistrate, made independent probable cause determinations based on the facts here, because it is very reasonable to think that evidence of a computer trespass claim would be found by searching these electronic accounts, the Facebook account, and then once that actually uncovered useful information, the Gmail address, the Google account, that would help establish that chain of where this video came from, who provided it to him, that would further the investigation into criminal trespass. This is the classic role of search warrants. And the rule that my friend on the other side is proposing would upend a lot of the reasons that the Supreme Court has articulated that we need this no probable cause element. It's easy to make allegations about an officer's subjective state of mind. And as Judge Diaz has indicated, it's really tempting to just dig into the discovery and try to poke around and see what you can find. But these are police officers and investigators that are doing their job. That's why our system provides this deference. We don't want to make these officers afraid to do fundamental investigation and have the criminal justice system grind to a halt. I think that the Supreme Court in Nieves speaks a lot about this. It says policing events like an unruly protest could make just any incorrect turn of phrase or anything turn into years of federal civil rights litigation. And as a result, it would dampen the ardor of police. That's something the Supreme Court has said that we should not do. The rules apply on all floors here, and just briefly, in my last few minutes, I'd like to point to qualified immunity, because even if this constitutional issue strikes the court as tricky or as something the court doesn't want to go into, qualified immunity manifestly applies and bars both of these claims. The very fact that the Supreme Court and this court have never addressed the questions that we have here, does the Nieves exception apply? Is no probable cause an affirmative element of a retaliatory search claim? That manifestly demonstrates that that law is not clearly established. So Officer Bocock's conduct, at a minimum, is protected by qualified immunity. Unless the court has any further questions, I'd ask that this court affirm the district court's denial of, or grant of the motion to dismiss and denial of leave to amend.
So can I ask you about this
Yes.
latter issue regarding qualified immunity
Yes.
and the retaliation claim? It seems a bit odd to say that an officer who is pursuing a search warrant and executing a search warrant, but has a retaliatory motive, would be immune from a civil lawsuit if he, simply because he didn't know that there would be an exception to the issue of retaliation. If he had retaliation on his mind, why would that not be a problem in terms of qualified immunity?
For one, there's no case on point that deals with this context and suggests that even if protected speech was part of a criminal investigation, that a validly issued search warrant was not, it would be a constitutional violation to execute a validly issued search warrant. And to your point about what if there is, in fact, a subjective motive of retaliation, the Supreme Court has made clear that we never look to an individual officer's specific subjective intent. And even in these retaliation claims, the court says it might be distasteful, it might be dishonorable, even if there is, in fact, a retaliatory motive somewhere in there, as long as the criminal investigation is legitimate, there is probable cause. And this would have gone forth such that the retaliation is not the but-for cause of the conduct does not violate the First Amendment. In light of that, there just simply is nothing that shows that the conduct at issue here was so clearly established that what this officer did, which was executing lawfully issued search warrants, would constitute constitutional violations. Nothing clearly establishes that, and qualified immunity manifestly protects his behavior.
All right, thank you.
Thank you. I ask that you affirm.
I think, Judge Diaz, that you've hit the nail on the head. Joe Stanley was singled out because he was a thorn in the side or a pain in the butt or whatever words we want to use of the town of Rocky Mount Police Department. He was never prosecuted. No one was ever prosecuted. No one will ever be prosecuted. They wanted his Facebook and Google records to know who he was talking to, what he was talking about, whether there was a group of people who were expressing disdain for the government, and it worked. It worked. To address your question, Judge Richardson, objective evidence of what? It's objective evidence of ulterior motive. That's what the court's looking for. This is what Justice Gorsuch said in Gonzalez, where the process was lawful. The point is the process, yes, it was supported and it was properly done, that it was supported by probable cause. The magistrate here signed off on it, but it was being done for an ulterior purpose. And I think that's the allegation here. That's the allegation.
What are you quoting there?
It's on our opening brief, Judge Richardson, at page 15.
It's the oral argument, right?
It is the transcript of the oral argument, yes.
So what you're asking us to, instead of reading Gonzalez, you want us to read Justice Gorsuch's question in oral argument.
I am not saying that the transcript or the oral argument.
Does it supersede Gonzalez and Nevis?
No. But the point is instructive, I think. The point he was trying to make, I think, is instructive, and that's the only reason that I offer it. We look for some ulterior motive, and I submit we have that here. My colleague sets up an impossible. First of all, they say probable cause is.
Is there anything from Nevis or Gonzalez that you want to cite? Any part of those opinions that you want to cite for this proposition that you just look generally for an ulterior motive? Because I read them the opposite way, and so I guess maybe help me understand where do you want me to look in Gonzalez or Nevis to come up with this idea that we just look for some ulterior motive, the existence of some ulterior motive?
Under Gonzalez and Nieves, what my opponent says is that you look for objective evidence of comparators. That's not in either opinion. That's simply not there. And that's why we need discovery. They say you need objective evidence of comparators, but you can't get any discovery. That's why we need discovery. And again, we're here on 12b-6, not Rule 56 or trial or verdict or some such. And also take issue with my colleague's argument that we don't want to dampen the ardor of the police. Maybe we do sometimes. And that's why we're here, because here they went after Joe Stanley to silence him, and it worked. So we need discovery as to certain issues, and I thank you for your time here this morning. I'll answer any additional questions that you may have.
Thank you, Mr. Grimes.
Thank you.
I want to thank both counsel for their able arguments this morning. We'll come down and greet you and then move on to our second case. Please be seated. Our second case is 23-4713. United States versus Jones. Mr. Anderson, whenever you're ready.
morning. May it please the court. Howard Anderson, CJA counsel for Mr. Jones. As the court is aware, we've got one substantive issue in the case and one procedural issue in the case. The substantive issue is whether the law allows a district judge to give the probation unfettered discretion to order drug testing during a period of supervised release. And then the procedural question is whether the plea agreement in this case or generally would prevent the court from reaching that question on the merits. Let me start briefly with the substantive question. On the
substantive question, can you start by explaining to me why Condition 10 actually assigns any discretion to the probation officer? I read Condition 10 as simply assigning who pays for the testing, while Condition 3 actually sets the number of tests. I know both parties seem to agree that it gives discretion to the probation officer, but I don't understand how I can read the language of Condition 10 to do anything other than direct who pays for the very number of tests that are assigned in Condition 3. And I don't know that we're going to ever get there, given the hurdles we've got. But you wanted to start with the substance, so help me understand how I read Condition 10 that way.
Sure, Judge, and to be clear, I have no objection to the court construing the language as written that only 3 tests are authorized unless Judge Kane or somebody else signs off on a 4th or 5th. I have no objection at all if that's how you want to interpret the statute. Again,
well, your argument is that it offers discretion to the probation officer to set the number of tests. And what I'm asking you is, what is the basis for your claim that it does that?
Well, one, I would say the government says that it does, and so that's the position that they take. I will say, again, this is on plain error, so I don't know exactly what Judge Kane had in mind. I will say that I have...
I don't really care what he had in mind, right? I care what he wrote down.
Right, and so...
And what he wrote down is, you must submit to testing, right? But we've already done that in Condition 3, and you must contribute to the cost of such program,
right,
blah, 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 and cooperate in securing third-party payment.
Right.
All of those things seem, you're not complaining that the probation officer can't facilitate partial payment for the drug testing program.
Not at all, Judge.
So help me understand why do I read Condition 10 in the way that you've suggested?
Well, again, Judge, I don't object if you want to interpret it that way. That would resolve the issue, all right? But again, I am litigating this in several cases. That condition, as you know, is a standard one in South Carolina. I have one where I was trial counsel. I objected with Judge Coggins, and then Judge Coggins says, no, I'm leaving it up to probation. So that's my view as to how the district courts understand that to mean. But if this court wants to say, you have to say, I'm now giving you discretion, I have no objection that would solve the issue.
I'm concerned with how you can get past the provisions of the plea agreement. You waived everything concerning the conviction or sentence.
And so, Judge, if I could just make one...
You should answer his question.
I guess, Your Honor.
Despite your desire not to, you should answer his question.
And so, Judge, what I am suggesting is that this court should align itself with, say, the Ninth Circuit in Wells, right? So the issue that we have here is that when the parties take a plea, they are assuming the risk that the judge will make findings that are against them. And so whatever is within the realm of a legally appropriate sentence, that's the risk that the parties take. My position here is that no judge could ever issue this. And so whether you want to view it as being above the statutory maximum or whether you want to view it as otherwise ultra vires.
Your view is any legal error is exempt from the waiver? I mean, that's I understand. The Ninth Circuit might do it in Wells. I will tell you as a rhetorical matter, when you respond to the question by saying you should adopt the Ninth Circuit's approach, I'm not sure that's the best rhetorical move. Maybe look at the Fourth Circuit, because that's not the approach that we take, right? We don't have this freewheeling, any error is beyond the power of the court, and so therefore the appellate waiver actually doesn't cover anything other than fact-finding.
Well, Judge, that's not my position here. If you look at At Lubkin, which the government cited in their 28 letter, there the opinion by Judge Wilkinson says, the claim that the defendant is making, which was different than what was at issue in Cornett, is that this defendant is saying, you can get 15 years to life if you're ACCA eligible. I just don't think I'm ACCA eligible. But Judge Wilkinson noted that the defendant wasn't challenging that if findings were made, that sentence would be legally authorized. Here,
It's fair. We have identified a few, as we've said, a few narrow exceptions to the plea waiver that are not included. And so what we've sort of described, I think, as sort of fundamental errors that would not have been contemplated by the parties, right? And one of those is sentencing somebody beyond the statutory maximum that could have been applied against someone in this person's situation, right? So if you sentence somebody for trespass, for, you have them be executed, right, we say that that's improper. We've included a few other fundamental errors like, sentencing based on race, right? Or sentencing based on random acts, right? If a district court judge sentenced based on throwing darts at a dartboard, right? We might say that that's the kind of fundamental error. Right, but we've never suggested that, like, the phrasing, the procedural phrasing of a condition of supervised release is such a fundamental error that it couldn't have been contemplated by the parties at the time. Have we? I mean, what's the best case you've got that suggests that this type of procedural issue is the type of fundamental error we've exempted from appeal waivers?
well, Judge, that's like the Cornett case that Lubkin cites, right? So my position on the appellate waiver issue is that my position in this case.
Cornett was exceeded statutory maximum.
Right, and so that's essentially what this argument here, that no judge, that the law does not allow any judge in any court to ever impose the condition that gives unfair discretion. That's the claim that I say is exempt from the appeal waiver.
But the appeal waiver says, in exchange for the concessions made by the government in this plea agreement, the defendant waives the right to contest either the conviction or the sentence in any direct appeal or other post-conviction action. That's about as broad as you can get.
With the exception of if it exceeds the statutory maximum, for example. And again, that's essentially the claim.
That's as broad as you can get.
But,
You're contesting something in the sentence.
And so if the judge had said, you have to get, drug tested every day for the rest of your life during supervised release, that would clearly fall within the waiver, because that would be within the realm of what the law allows a judge to say, and I might agree or disagree with the judge as to whether it applies. That would fall within the waiver. My claim here, for the purposes of the appeal waiver, is that this condition is not allowed by any judge ever, and so therefore it could not have been within the contemplation of the parties that a judge is going to sentence someone essentially at whim to something that he lacks the power to impose. And that's the very narrow claim here. Going back to the substantive point that I wanted to make here, the government wants to draw a distinction between special conditions and mandatory conditions. The First Circuit in Padilla, the Seventh Circuit in Bonanno, the Ninth Circuit in Stevens, the Tenth Circuit in Miller, they did not draw the distinction between between special and mandatory. As an officer of the court, I will report that the Sixth Circuit has recently adopted the government's position, and I want to make sure that the court is aware of that. And that's a case called Vaughn, 119 F. 4th, 1084. That was decided at the end of last year. So there is one circuit that has adopted the government's position. I don't think that's at all fatal to this case, even on plain error, because on the substantive question, I would just like my colleague to answer this question. This court has said that it is...
That's not typically how it works, right?
I know, but I would encourage you to ask him this question. This court
That's not typically how it works either.
I will just posit this then, Your Honor. This court...
You're getting there. You're getting much closer.
This court has said that it is an illegal delegation to give the probation office discretion to set the number of restitution payments. And I would suggest that there is no fundamental difference between setting the number of restitution payments and the number of drug tests. And that has been the law in this circuit since 1995, U.S. versus Johnson.
Does it depend on the purpose of the drug tests? There's a distinction, isn't there, between drug tests for enforcement purposes and drug tests for therapeutic purposes?
And so if it's being done, in the context of sort of drug treatment, in a drug rehab facility, that's not being run by probation, that's being run by the provider. But the problem here, as noted in the brief, the substantive problem is that Congress has stripped the district court of discretion as to what to do if the drug test comes back positive. If you fail 2 within a year, we have to revoke your supervised release. And precisely because the judge has no discretion on the back end, we need to make sure that the judge is exercising discretion on the front end to say how many times you're going to run this gauntlet. And it is very hard for poor people to go. I have had clients that get violated on supervised release, and they have asked me to bargain in plea bargaining to resolve supervised release. Please give me more time in prison just to release me from the supervised release, because it's really hard when I live out in the country and there's no bus, and I got a job at McDonald's, but I got to go to the drug testing office on short notice, and I got to find a ride. It's a huge burden. I've had at least 2 clients that have traded more prison time on a violation for supervised release just to be done with this. And so I submit that it's a serious claim, and it's not just semantics here, Judge.
So even if let's assume we agree with your view of this, what this condition is intended to do. You indicated at least twice, maybe more, that we're on plain error review. So how is this plain error?
And so, Judge, as you know, you first have to decide if it's plain, was there error? Then second, was it plain? I submit that given the 5 other circuits that have said this, the plain language of the statute, and given Johnson, which says that you can't delegate a restitution, I think that would qualify as plain error. If for some reason the court says that that the 6th Circuit has now muddled it enough, I will say that there are several other appeals that I have that are stayed in this case, including ones where I have objected at the trial court that are coming up here. And so this court is going to have to address it at some point, because I think I've got 4 other appeals that are going to raise the same issue. And so I would encourage you just to go through the analysis in the interest of economy. First decide, was it error? Yes, no. And then, was it plain? Yes, no, because you're going to reach it, because I've got several others that have been held in abeyance pending this decision where I did object as trial counsel.
All right, thank you very much.
Thank you, Your Honor.
May it please the court. Your Honors, I share the same concern. I'm not sure how we get past the appeal waiver in this case. Mr. Jones entered a knowing and voluntary appeal waiver in exchange for substantial benefits, where he agreed to give up his right to challenge matters decided at a sentencing hearing. This procedural question as to whether and what level of discretion probation may or may not have been granted in Special Condition 10 is clearly a matter decided at sentencing. This court decided in Lewis and in Harrison that conditions of supervised release are a matter of sentencing, and that they do fall within the scope of a knowing and an intelligent appeal waiver. Under Blick, with this fulsome Rule 11 hearing, this broad appeal waiver language, which Mr. Jones does not challenge and does not contest, the appeal waiver is enforced.
Can I ask about that?
Yes.
So don't we assume the basis for counsel's argument that he's alleging that this provision gives the probation officer unfettered discretion to determine how many drug tests James should undergo when he's released, whenever he's released. And so if we assume that to be true, why isn't that a sentence in violation of the law that no judge would be authorized to impose? And so, I mean, you may disagree as to whether or not that's correct, and so that's the merits argument, but why, if we assume that to be true, why isn't that beyond the scope of the waiver?
Well, I've got to acknowledge, I should have probably even acknowledged as soon as I came up here that we agree with Judge Richardson's read of Special Condition 10. What we did when we briefed this case is we assumed the construction of the conditions as Mr. Jones framed them. We actually think that there's a better reading that...
Yeah, but that's not responsive to
Sorry.
the Chief's question, because the Chief's question says that's a merits question.
Sure.
And when we look at a plea waiver, we don't make a quick look at the merits and
Right.
determine whether they're frivolous or not, but instead we accept their argument for what it is, and we evaluate whether it is first encompassed within the plea waiver, and then whether there's, a carve-out to the plea waiver that's sort of analogous to saying, this is like a sentence that exceeds the statutory maximum.
That's right.
Right? And so going to the merits is sort of
That is.
non-responsive, right? So why is this not like sentencing a 10-year statutory maximum defendant to 15 years? Because we've said that carves out of even a clear plea waiver. Why is
Right.
this not like that?
Right. This is very unlike Cornett. Cornett, this
Well,
court
why?
in Lubkin, Judge Wilkinson wrote that Cornett was a unique circumstance where retroactively the Supreme Court found the residual clause unconstitutional. And when the court did so, they said that the district court never had the authority to impose a sentence under the residual clause at all. And it was never a source of lawful authority to sentence the defendant in Cornett. Here, the dispute is as to whether the 3553A3 statute on delegation requirements was complied with by Judge Kane or not. Where I meant to go when I was dabbling in the merits, and I think that I take the judge's correction well, was that we don't believe that probation office has been given unfettered discretion. We think it's a financial condition. We think it adds to and does not contradict. We think it simply says you must pay.
But even if it did, so what I thought you were going to go to was, even if it did, accepting the chief's sort of framing here, and you might want to fight the framing. You might say, we do look at the merits. I don't know. But if you accept the chief's framing that we accept the merits of the claim, and so we assume for a minute that the probation officer was given unfettered discretion to set these.
Right.
Contra reality, but I think we might accept that as an allegation. I thought what you would say is like, this is not the type, this sort of procedural supervised release provision is not the type of fundamental error that would have been beyond the party's contemplation, right? You went to the court in Blick, you might think about the court in Thornsbury that sort of says, like, yeah, there's these like core fundamental problems, right? So if you're sentencing based on throwing darts, or you're sentencing somebody that was supposed to get 10 years to 20 years, those are like so fundamental, effective miscarriages of justice that we're gonna ignore the plain language of a plea waiver.
Right.
All right, I accept those.
Right.
The question is, do we extend that to procedural aspects of a supervised release violation? Because they're not, one might posit, quite so fundamental in the structure that we have here.
Well, if we do, it would be a very different exception than the way Cornett describes. And if we do, then we're going to be here on 3553 errors, even after appeal waivers, because that is a statutory delegation to what a court must do at sentencing, what it must consider, and despite appeal waivers, we're going to start calling those fundamental defects that unwind convictions and sentences. It's going to undermine, as Lubkin indicated, that one of the chief bargaining chips that defendants have to offer. It's going to require the court to do in-runs around appeal waivers and litigate the merits before deciding whether to enforce them. But instead, what we have here is not one of these core fundamental violations, such as a sentence that exceeds the statutory maximum, sentencing based on race, a plea that is affected by ineffective assistance of counsel. So there's a Sixth Amendment violation even in entering the appeal waiver at all. This is like none of those. This is a six-word sentence in Special Condition 10 where the defendant is concerned that too much authority has been delegated to a probation officer for a term of his supervision after he's released from prison. That is very unlike those fundamental defects that this court has recognized. And even when he invites this court to adopt an approach in Wells, look at Wells. Wells rejected this argument. Wells wrote that it declined to extend the meaning of an illegal sentence, this is Wells at 585, to encompass sentences that potentially violate Section 3583D. So even the Ninth Circuit approach, which is somewhat like a Cornett approach, looking for illegal sentences, somewhat like what was argued in Lubkin, even Wells said 3583D errors are not illegal sentences within the Ninth Circuit's framework.
Well, I think our cases make the point that a district court can't delegate what are considered to be core judicial functions to another party, in this case the probation officer, So for example, I think it would be beyond the scope of a waiver if the court were to delegate whether or not a defendant should undergo a certain kind of treatment, sex offender treatment, for example. So why isn't this case more like that than not?
Judge, you're right. What this court has said is that district courts decide these core judicial questions, whether to impose a condition. Broad parameters was language used in LBAS. General parameters, rather, was what was used in LBAS. Broad framework has been used by this by this court, rather. Ultimate jurisdiction over whether to revoke. But this court has also said that substantial discretion over management, administration, means, and details are deferred to probation. And in this case, we can't ignore mandatory condition 3, which is a part of the judgment, which does say that the court retains the jurisdiction. Not only does the court ultimately decide whether he's drug tested, which the court has decided, so it's not delegating the whether question to probation, but also the court's maintaining discretion and jurisdiction over the number of drug tests. So the deficiency that Mr. Jones complains of actually is in the judgment. It's in mandatory condition 3. And looking at special condition 10, what it adds is a financial obligation. It's less detailed, but it does not contradict, and it does not provide any express delegation like the out-of-circuit cases like Padilla, for example, Stevens, Bonanno, where there are express delegations with that language as determined by the probation officer. That is not found in special condition 10. So instead, what we have is a broad framework laid down by the court, and we have substantial discretion as to means and details left to probation. But with this condition, the only discretion probation has is to help collect payment. There's not a discretion delegated to probation on the number of drug tests in special condition 10. And so...
So is it your view now, I understand
Yes.
that the briefing went by, if instead of what condition 3 says, which requires 3 drug tests,
Right.
But as determined by the court, so the court is determining at least the second and third and further drug tests. If the probation officer said, like, I'm telling you, you've got to do it without court approval, is it the government's position that that would violate the plea agreement, or, I'm sorry, would
Right.
violate the judgment that the district court entered here?
It would. We believe that the judgment has authorized 3 tests, and if probation wants more, it needs to move to modify the conditions. And it can do that.
And the court can do that.
And that happens.
Probation can go to the district court and
Absolutely.
say, he's failed 2 out of 3, we need to keep doing this, but that requires court approval.
That's right. The court ultimately retains the jurisdiction over the numbers question. The numbers question, it appears, is what Jones is primarily concerned about. And with this framing, with this mandatory condition 3, the court has that discretion, not the probation officer. And if he fails a few tests and the probation office petitions the court and says, we need 10 tests, we need 12 tests, we need weekly tests, it would be Judge Kane who authorizes that, not the probation officer.
Are you conceding now that those plea waivers don't mean what they say?
I'm sorry, Judge.
Aren't, right?
I'm sorry, I didn't understand the question.
You're conceding that these plea waivers or sentence, the waivers don't mean what they say in the plea agreement.
I may be too dense to understand the question, Judge. I think the appeal waiver.
Appeal waiver. I'm talking about the, yeah. The waiver in this thing, waives the right to contest either the conviction or the sentence.
We believe it means what it says and that it should be enforced.
But we got to look at everything to see whether it means what it says.
Well, Judge, the only way that I could see that happening in this case is under Attar footnote 2. The constitutional exception that this court has recognized does say in footnote 2 of Attar that there must be a colorable constitutional claim. And if this court wants to go down that road and engage in some analysis as to whether there was an unconstitutional delegation, that may require some peek behind the curtain. But even much like Wells, the constitutional cases that Mr. Jones cites are also fatal for him. Padilla wrote 415 F. 3rd at 222 that the placement of the authority to set the maximum number of drug tests in the hands of a judge is a statutory choice. It is neither a matter of constitutional necessity nor a condition necessary for the fair administration of justice. So Padilla says it's a statutory error, not a constitutional error. Miller says the same thing, that Mr. Miller, the complaint that Mr. Miller advances, quote, was not an unconstitutional delegation of the court's judicial authority. That's Miller at 763. Bonanno, again, says that what Mr. Bonanno complains of is that the court went beyond the parameters of the statute and of Section 3583D. So Padilla, Miller, Bonanno, they all say, even the cases that Mr. Jones advances, that this is not a constitutional error. This is a statutory error. This is what Lubkin wrote about. The ordinary business of trial courts are legal errors. This is what happens. And when someone gives up the right to challenge a legal error, they don't get to ignore the appeal waiver by using the word unconstitutional or illegal. And we're afraid that that's what Mr. Jones has done here. And so our ask, Your Honors, is to enforce the appeal waiver. Our ask is to conclude, if Your Honors must reach the merits, that there is no impermissible delegation. The broad parameters, the decision of whether to impose the condition, the broad framework was all imposed by the court. The means, the details, the management, the administration, that is all fair game for probation to have. And they don't have any more than that in Special Condition 10.
But they make for a lot of litigation on post-sentencing. When I was a prosecutor, and that was almost 10 years total, we didn't,
I thought you were saying it was 10 years ago.
much more than 10 years ago,
During the Betamax era, that's what it is.
I was wondering what that was.
we didn't get anybody to waive an appeal. We thought it was a good idea to get the appeals court to review it. Because we didn't have the sentencing guidelines, but there were no appeal waivers. Anybody could appeal if they wanted, they didn't like it, if they could go on. So it's a new thing after I left the prosecutor's office. And if you're gonna do them, I've seen me like about to enforce them.
Right.
The contracts, we've said that,
Not only that, Judge King,
but
but
you give up, but the government gives up, you said in exchange for concessions made by the government, whatever they were,
right.
give up 3 or 4 counts to get one.
That's right, Judge. The government moved to dismiss multiple felony counts. He received acceptance of responsibility. The federal prosecutor negotiated with the state prosecutor to dismiss state charges. He was looking at a mandatory 25 years in the state system. That case was dismissed after the federal prosecutor requested it be dismissed. That's also on the record, at least the negotiations of the back and forth between the AUSA and the state prosecutor. If Mr. Jones wanted to advance challenges to his sentencing conditions, he could have negotiated a different appeal waiver, but he didn't. Or he could have pled without an appeal waiver, or he could have gone to trial. But he's already made his choice, as Your Honors indicated, on giving up his right to have these challenges, to have these conversations. And it undermines the benefit of the bargain for the government and the court spending resources and time here. And if we believe that it's not going to be a benefit to the government when a defendant signs an appeal waiver, there's a lot less bargaining chips that the defendants have to bring to the table for us. It's going to hurt defendants in the long run. This is taking away, if he's allowed to still appeal despite an appeal waiver, one of the most substantial things a defendant has to offer when negotiating for a better plea. And so Mr. Jones may think in a narrow sense this hurts him, but this does help defendants situated like Mr. Jones in the long run by having Mr. Jones and those like him bringing something substantial to the table for the government so that we don't have to be here litigating procedural questions in language of special conditions if he's negotiated away his right to challenge them later. And for that reason, we ask the appeal waiver to be enforced. And if we reach the merits, Judge, we ask you to affirm. And if the court has no further questions, we will rest on our briefs.
Thank you, Mr. Daniels.
Thank you very much.
Thank you. A few brief points in reply. I heard my colleague say that this is not like sort of Lubkin because there's not the claim that the district judge never had the authority. And that's exactly what I'm saying here, that the district judge, for the purposes of the appeal waiver, the claim is the district judge never had the authority to issue a condition. So it is illegal. And in fact, I would note that this as determined by the court language was added by Congress.
So I took your colleague's point to be slightly more nuanced than that, that there is no doubt that the district court had the authority to issue the condition, right? The question is, did it have the authority to issue the procedural means of carrying out that condition? Right? You're not disputing that the district court had full authority to order drug testing.
I concede that, but I say that it lacks statutory and constitutional authority to say you do drug testing, whatever probation says.
Right, but the rub there, right, is that as soon as you say that, right, so they had the authority to do this thing, right, but the means of doing it was in play, then you've just, the result of your argument is that there is no waiver as that applies to anything other than fact-finding, right? Because that would also be true in saying under 3553A, the district court has no authority to sentence without considering the nature and circumstances of the offense, right? And so, because that's there, if that's your argument, you just say that's beyond the statutory authority, right? And so it seems like to me, we have drawn a much narrower line than that of those things that are so fundamental that they could not have been contemplated by the parties.
No, Judge, what I'm saying is that for your 3553A factor, we look at, well, what was the number that sort of popped out? And the number was 240 months. And as long as that's within the statute.
I think you've read enough of our cases to know we don't just look at the number up here.
Well,
we actually look at like the details given and the arguments that are raised and the responses that are made. We do not just look at the number under 3553A. In fact, we are quite demanding of district court judges with respect to each of those factors where non-frivolous arguments are made.
Well, Judge, what I was saying is for the purposes of an appeal waiver, what we look at is what was the number that popped out? Is that within the statutory maximum? Yes, no. You have an appeal waiver. It's under the ceiling. End of case. My argument here is that this condition is beyond the power of the court to impose.
How is that any different from a claim that a particular enhancement is beyond the power of a court to impose? The court makes a mistake, you allege, I mean, that happens all the time, but we say that's barred by the appeal waiver.
Right, so it would be statutorily authorized upon certain findings. I'm saying here that there are no findings that any judge could ever make in this country or in this circuit that would authorize the condition if it means what I thought that it meant before I heard the government's concession here. But that's the position for the appeal waiver, is that it is beyond the power of the court to impose. And I note that prior to 1994, probation had the authority to do unlimited attest. And Congress added that language in 3583D that as determined by the court in 1994, which according to the First Circuit was designed specifically to restrict the power of probation. And so my claim, again, for the purposes of the appeal waiver, is that the judgment has a provision that is statutorily unauthorized, just like in Johnson. It's a statute that says that the court's got to set the schedule for restitution. In Johnson, this court said it's an Article III problem if the court doesn't follow that. And so this is just like Johnson, that it's a constitutional problem because Congress has assigned a decision maker, and that decision maker is the judge. And so for the purposes of the appeal waiver, I think you say it survives the appeal waiver because the claim as framed is it's beyond the power of the court to impose. Then when you get to the merits, if the government is fine to say, but no more than any test beyond 3 has to come with the signature of Judge Kane, I am fine with that concession, and that would solve the issue. I think it'll come as a surprise to probation, but I am fine with that because that's the position that I am arguing here. And so if that is in fact how you're going to interpret it, A-okay with me. Just go to probation because that's what you're supposed have probation go to the judge because that's what I say that the statute requires, where the judge has to set some schedule, and that's all that I'm asking here. And so this is a very narrow exception that I am.
Do you agree, I guess, assume for a minute that I think it doesn't, the condition 10 doesn't delegate anything. Do you agree that the condition 3 authorizes 3 tests to be done?
Yes.
Okay. And then other tests as ordered by the court?
Yes, so as long as it's got...
Right, and is your argument that the probation officer has no discretion with respect to the day for those 3 tests? Like if I wanted to be on Tuesday, September the 15th, right? Is that something the district court has to do? Or do you agree that once the district court has ordered 3 tests, which it has done in condition 3, that the day on which they are given is something that the probation officer can determine?
I would say that with respect to the first test, Congress does give a sort of time frame when that first test has to happen. As to 2
And that's described in
Yeah,
condition 3.
but as to 2 and 3, probation can sort of set that. And I would note, for example, in the Seventh Circuit, they say, what the judge has to do is to say that probation can give you tests no more than 4 times a month, no more than once a day. And so I don't have an issue with when probation runs the test. I just have an issue with the number of tests that they're going to run, because again, if the client pops up positive twice.
Would it be in your view, a constitutional or statutory problem if condition 3 instead said, you got this first test that's sort of unique because of the timing, and then the defendant shall undergo no more than 100 tests, and no more than 4 in a month, within the discretion of the probation officer. And then the probation officer could decide to give 2 tests or 100 tests. Would that be a permissible context, because the district court there has indeed ordered up to 100 tests?
And Judge, if I could answer, my time has expired.
Go ahead, please.
Thank you. Yes, in fact, that's exactly what the Seventh Circuit does. Because I, as a defense attorney, I can challenge the sentence, and so I can say, under 3553A, the court should not have imposed that. Now, again, not with an appeal waiver, but in a regular one, I can come to this court and I can ask this court to engage in a reasonableness review and to say, doing 5 tests a day is unreasonable. So we're going to send it back, and in fact, that's what the Seventh Circuit has done, that sometimes the judge goes way overboard, but when the judge says, that it's going to be no more than once a week, that gets affirmed.
And you're saying you can raise all those issues even without presenting them to the district court at sentencing? You can come to the Court of Appeals and raise Cain about all that stuff without even raising it in the sentencing court?
I would say that on...
You'd have an imaginative court-appointed lawyer.
Well, thank you, Judge. Thank you, Judge.
To keep us working.
I'm not sure that was a compliment. I know you took it that way.
I
but
did.
I'm certain it was.
Yes, Judge,
That was a compliment.
I'm trying to make sure
It
that...
definitely was a compliment.
I am trying to make sure that we
You
keep
got
this
us,
up here.
you got us up here arguing about this thing, and this plea waiver says you can't appeal it.
And so, Judge, what I would say is...
The sentencing waiver
Yeah.
says you
And, well, so again, setting aside the appeal waiver, if the judge says, test, no more than 3 times a week, and the defendant didn't object below, it's going to be hard on direct appeal to say, well, you didn't complain about it, so it's got to be so unreasonable that the Fourth Circuit exercises its...
You're mousetrapping the district judge. That's what this stuff about plain error is. You're supposed to present your issues to the sentencing court.
Right.
To the court. And then you get review of them when you come to the Court of Appeals.
But the issue that I'm raising here, Judge, is that if, for the purposes of the appeal waiver, that the judge imposed a condition that is ultra vires, it is beyond the limits of what Congress has authorized any judge to ever...
That's not what you have here. You're way off in blue sky.
But for the appeal waiver, that's how, that is what I say survives the appeal waiver, is that it has to be that very narrow claim, that it's beyond the power of the court to
If you can
impose.
conjure up some circumstance that doesn't have anything to do with the case, and then you got a right to come up here and complain. That's what your position is.
To survive an appeal waiver, it is a very narrow exception, and so I would have to frame the argument as one that the judge has done something that exceeds his power under the law, that no judge ever could do it, and that's what I say here. Again, now having heard the concession, I would just say, fine, the appeal waiver doesn't apply. If you would just sort of say that the government says that this condition means the probation's got to get Judge Kane to sign off on test 4, 5, 6, I've got no complaint about that, and that'll clear up everything, because this is a condition that everybody uses in South Carolina, and it'll be clear to everybody as to what it means. I have no objection to that, if that's the position the government takes.
Or alternatively, we can just not answer the question, and on test 4, your client can challenge it.
But I would say, Judge, that again, I've got several other appeals that are coming your way from South Carolina.
We don't decide this case in order to resolve a case that is not yet before us. That's not typically what we try to do, right?
Well, I'm going to say that that concession from the government, I'm going to be making that sort of when it comes. All I'm saying is that if that's what this
Good luck
condition...
to you before those panels.
And so if that's what the condition means, then my claim can, the sentence can be affirmed because there is no constitutional problem if Judge Kane is in fact signing off on 4, 5, and 6. And so that would be a very short opinion to write.
We love that.
Yes, sir.
Thank
Be
you.
short to just say the appeal waiver applies too, but.
A bit too short, Judge, but thank you.
Thank you, Mr.
Appreciate it.
Anderson. I want to thank the both counsel for their valuable arguments, and Mr. Anderson, in particular, I want to thank you for taking this case on as a court-appointed lawyer. Even more grateful that you're doing that, knowing full well, as maybe some folks don't know, that our court-appointed lawyers are essentially working without pay since July 3rd because of budget problems and concerns, which hopefully will get resolved. But we thank you for that. We also thank you for making the court aware of the adverse authority in the Sixth Circuit. You know, that's obviously something that we should expect of lawyers, but it's refreshing that you did that here today, and we're grateful for that as well. And Mr. Daniels, thank you for ably representing the interests of the United States in this case. We'll come down and greet both of you and then take a short recess before moving on to our final 2 cases.
This honorable court will take a brief recess. the judges of the United States Court of Appeals for the Fourth Circuit.
Be seated. Our next case is 24-4468, United States versus Brewer. Ms. Torre?
Good morning, Your Honors. May it please the Court. Lauren Torrey on behalf of Appellant Kristen Brewer. The District Court in this case erred as a matter of law when it applied the abuse of trust adjustment under United States Sentencing Guidelines, Section 3B1.3. We're asking this Court to reverse and remand for resentencing without the guideline adjustment. Now, because the Court does not need to reach the Kaiser issue, if it finds that there was no abuse of a position of trust, I'll focus my argument on the legal question of whether Mr. Brewer occupied a position of trust, unless directed otherwise, of course. When analyzing the question of whether an individual occupies a position of trust, this Court must determine if there is a fiduciary role or something akin to a fiduciary role. How it does that in this circuit is it looks to three factors, and those factors come directly from Berenger and Brack. The factors are, one, whether there are special duties or special access to information not available to other employees. Two, whether the defendant had broad discretion, and in this case, over the funds. And three, whether the defendant is more culpable than others in similar positions.
So can I stop you there? Because when I look at our cases, this is not your fault, but it seems like we have two different tests that are applied. One is the relationship test, and at least goes back as far as Kaplinger in 2003. And then we do have this separate three-factor test, which sometimes we call a four-factor test, that is in Berenger, but also shows up in Cote and some other places. Do you have a view on the right way of doing this? We've sort of suggested sometimes you look at these and sometimes you look at those. They're just different tests. Maybe you can harmonize them in some way. Do you have views on what we're doing? You seem to pick one of what seems like three different lines of cases to give us the test. Why that one, and what do you have? Do you have views on this? Or you can say, I have no idea what you're talking about, and just move on. Either of those are options.
I understand Your Honor's sentiment. I too share that there's this sort of disharmony among cases. I perceive this three-part test to be most useful when the nature of the position is in doubt. How I look at the cases when I look at, in this circuit and other circuits, there seem to be these two sort of paths the court can take, and I think Your Honor described it as the relationship itself. And in some cases, we see the court, it's a clearer, more obvious answer when there is a fiduciary role established by some sort of legal relationship. So there are state laws that regulate the role itself. And then there are other cases where I would say is more a position of doubt when we're dealing with, in this case in particular, financial advising, and it's not a licensed position, where I would suggest that the most useful case law are these three factors and how
The
the
challenge with
evidence.
these three factors is, like, they don't really seem to be relevant into a solo actor, right? They're all about, like, members of an entity, right? What access to information do they have not available to other employees? Well, that factor, like, obviously can't be applied to a solo person, right? The question of are they more culpable to others in similar positions, that's within the same entity, right? So I guess I have a hard time even understanding what this test means in the context like a client like you have. And so I sort of thought maybe these three factors apply when we're talking about someone within an entity, and the relationship test applies when we're talking about really just like fundamentally the relationship. Maybe can you tell me how it would be useful to ask what information your client had that was not available to other employees? Who are the other employees that we should look at?
And so, Your Honor, as a part of that, the first factor, the court also mentioned special duties. And so while the court could look at that from the perspective of in a role in a business or a company, the court can also look to it as whether there are special duties for an individual
But
that
compared
has
to
a.
other employees, right? It's special duties that other employees don't have, but we don't have any other employees. It literally seems like it's a null set. It's like, do you have more than an apple? I don't even know what that means, right? Like, help me understand that.
Understood, Your Honor. So I would point the court to cases that involve solo actors like the bail bondsman, an individual who is working on their own, or a certified public accountant that might not work for one company but services multiple companies. What the court is looking at as to those special duties is whether there is this fiduciary responsibility to the individuals that they're servicing or their clientele. And so in this case, and I do understand the court's issue with how this applies to a person like Mr. Brewer, and I'd agree that it doesn't. Here we have an individual who is not acting in a highly regulated role, such as a lawyer, a bank executive, a doctor, a psychologist, a certified public accountant. We're dealing with an individual that had friendships with the investors in this case, took money from those individuals, purchased particular stocks, and then failed to provide payment in return. And here, what's most interesting is that even if we're looking at just the relationship, Your Honor, there was no evidence in this case that Mr. Brewer was paid to act as what I would consider something different and apart from this case, which would be sort of an investment broker, someone who is licensed. He never claimed to be part of a company or a business, or that he had his own firm as a solo licensed practitioner. This is someone that does not fit within this framework because this guideline shouldn't apply to him. And so when we look at defining the fiduciary role, even if we are just considering this to be just a relationship, I'd point the court to United States versus Kaplinger, where it states that in every fraud case, the defendant will have gained the confidence and trust of the victim. Trust is insufficient. A position of trust is a term of art. And so this court needs to determine if there is a fiduciary relationship or something akin to a fiduciary relationship or that of a trustee between Mr. Brewer and these investors, of which there isn't. Additionally, when we look at discretion.
Why isn't it the case that anytime someone is entrusted with someone else's money, that sort of is akin to a fiduciary relationship? He did hold himself out as a pseudo-financial advisor. You say he had limitations with respect to the stock purchases, but those were only descriptive, I think, of what he said he would do on behalf of the clients. I don't think the clients limited him in that way. I think he was fairly free to do what he thought was best for the clients, or at least the clients thought that that's what he was going to be doing. So why isn't it as simple as that? Anytime you take somebody's money with the representation that you're going to invest the money on their behalf, you're acting in a pseudo-fiduciary role, and that's an abuse of trust.
I disagree, Your Honor.
I'm not surprised.
The distinction here.
And your client said that to the court. He said, I quote, took people's trust, end quote, let them down, unquote.
Yes, Your Honor, but when we look at precedent, trust is not enough. There needs to be something else. And I would point the court to the cases that are cited in the briefing that deal with financial advising or brokers, investment advisors, people that claim to have those positions. And in all of those cases, what is similar is that the court is looking at this discretionary piece. When we look at United States versus Queen, it says that an investment advisor broker is typically an individual who is entrusted with the discretionary authority to manage assets of his or her clients.
Do you think these clients limited your client's discretion with respect to how their money was handled?
I think that it is the government's burden to show that there was broad discretion. It is not our burden to show that the discretion was in any way limited. And when we look at what the government provided in this case, they have a preponderance of the evidence to prove that this guideline should apply to Mr. Brewer. They failed to provide any evidence of discretion here based on what was provided in at sentencing or in its sentencing memorandum. And here, Your Honors, while the court...
What might just be a restatement of the Chief's good question, do you think an agent like anytime a principal has an agent, that agent is in a position of private trust, right? They're granted some authority, right? They're required to take actions consistent with the principal's interests, right? Like that's the type of interest we've got. Do you think an agent of a principal occupies a position of trust?
I think it depends.
Private trust, to be precise, I guess.
I think it depends, Your Honor. That agent would need, well, at least what the courts have pointed to in case law are sort of this indicia of, and this language isn't in the court's case law, but this indicia of reliability, right? We have individuals who have claimed to have licenses, individuals who have been given broad discretion by the victims to manage a large, for example,
No, but I give my law clerk some money and I tell him to go pay my water bill. I don't do that, obviously, Chief, to be very clear. This is purely hypothetical.
We'll investigate.
Right, but, and he, in doing that, and he passes a store and decides to go, make bad choices, like, he's violated my trust, right? I gave him the $100. He was supposed to take that money down to the water bill place, wherever you go to pay your water bill, and he's supposed to provide it to them. I've trusted him to do that. And in any, sense, he is my agent, going to pay with money I gave him. He occupies a position of trust to me, right? I gave him money to go do it. I guess I have a little hard time seeing why this is hard at all, because it seems like to me almost every agent would occupy a position of private trust. Like, I'm giving them money. And here they gave your guy a ton of money. And in doing so, they trusted that he was not a crook.
No, Your Honor, I disagree with that any agent would establish a position of trust. And this is because the colloquial term of trust is not what we're applying here. We're trying to determine if there is some sort of fiduciary role or something akin to a fiduciary role. And when providing money to a friend...
You don't think he's got a quasi-fiduciary responsibility to take the money and actually provide it to the water bill place? And so that he can just go buy a bunch of Snickers bars and gorge himself. That's totally fine. That doesn't violate any kind of obligation he owes to me.
No, Your Honor, because, not in this sense, because the court has said that it's looking at, or it's trying to differentiate between a typical commercial contractual relationship and that of a trustee. So I point the court to contracts. Contracts can exist where an individual it's just a commercial relationship, and those where the role of a sort of trustee has been established. Those are different things that can both exist. And so in Your Honor's case...
An arm's length contract is different than an agent. Totally agree, right? So I take your point. And if we had an arm's length contract, that'd be one thing. But what I'm describing is an agent. And that is not an arm's length contract, right? It is an agency relationship, which implies a quasi-fiduciary responsibility.
But there was no agency relationship in this case. Providing funds to an individual doesn't create something that is beyond, at least in this case, the ordinary social relationship, which there needs to be something more. It doesn't, and again, anything that goes to whether the victims had confidence in the outcome, to what Your Honor was saying was, I expect that individual to pay the water bill. But I point this court to the First Circuit in United States versus Syker, where it says, testimony by individuals that they trusted someone who betrayed their trust does not itself establish that the position was a position of trust. And so there needs to be something more than this violation of what we understand to be trust, because that applies in every fraud case.
What was the context of that First Circuit case? What was alleged happened there?
There in Syker, the individual was... I'm sorry, Your Honor, I'm not finding it in my note.
Well, I mean, you've got some time for rebuttal. You can come back and respond to that. But
Of course, Your Honor. But what I would like to note is that this is not what we would consider the traditional financial advisor in this case, because he was not given discretion over the funds. He was not permitted like a typical...
But he misrepresented himself as an experienced financial advisor and as a successful trader and a successful businessman.
Yes, Your Honor, he did misrepresent what his true well, if he had said that he was a licensed investment broker, that would have been misrepresentation. But if this court is going to
A day
reach...
trader, a stock market investor, a financial advisor?
Yes, Your Honor, but if the court finds that there is this fiduciary role, then it must then determine whether imposters count under the guideline, of which we argue it does not, based on Kaiser. And so if the court would like me to turn to that argument now, I can with my very limited time. But in short, the guideline
And
here...
it was at the sentencing that he told the judge he took people's trust.
Yes, Your Honor,
He
but...
told Judge Cogburn that. At the sentencing.
That is the only finding by the district court here, is that the victims trusted Mr. Brewer, but trust is insufficient. There needs to be something more for the guideline to be applied, because when we look to the special duties, the discretion that he had over the funds, and whether he's more culpable than others in similar positions of frauds that are like these, when we look at the case law, the government hasn't met its burden to show that these factors apply in their favor. Further, the guideline here is unambiguous, and under Kaiser, the court can't defer to Note 3, so imposters do not count.
All right, you've got some time for rebuttal to speak a little bit more about that, so.
Thank you, Your Honor.
Ms. Wood? Morning.
Good morning, and may it please the court. Julia Wood on behalf of the United States. The district court did not err when it applied the abuse of trust enhancement to Kriston Brewer. It didn't err as a matter of law when it found that imposters can qualify for the enhancement, and it did not clearly err when it found that under the particular facts of Mr. Brewer's case, the enhancement applied. I'll turn first to this issue of whether he held in a position of trust. I don't understand there to be any real dispute that a legitimate investment broker, trader, or advisor holds a position of trust. The court very clearly said that in Queen, and this court has cited Queen with approval in many cases, in Bolin, for instance, which is directly on point here. So I don't understand there to be any question that if he had actually been a legitimate broker and he took these people's money and he stole it, that he would have abused a position of trust. And our position is that since he did represent himself as a broker, a trader, an investment advisor, that he did abuse these victims, that he did abuse a position of trust, even though he wasn't a legitimate broker. I'll turn to the legal question. The district court did not err when it determined that the abuse of trust enhancement can apply.
Do you have a view on the Chief's question, which is, it is an abuse of private trust, if I paraphrase correctly, Chief. Anytime somebody gives you a large sum of money to do something with, whatever it might be, but certainly to invest, that creates a position of private trust between the two people.
When someone gives, yes, when someone gives a person money to invest, gives them discretion to invest it, yes, I do believe that that would constitute an abuse.
And so in that sense, it sort of doesn't matter what he represented himself to be or otherwise, right? It sort of just, like, if he's convinced his friends or otherwise to give him a large sum of money to go, buy things with, and he does not indeed go buy those things with it, then he has abused his position of trust in doing so.
He has abused his position of trust under those circumstances, yes.
So that's different, I guess, I think it was a Sixth Circuit or Seventh Circuit, the country club fellow who, persuades his buddies to hand over some funds. The court there said that without more, that wasn't enough. You would disagree with the holding in that case?
I think there's a distinction in that case, you have someone who is purporting to be a businessman, or he is a businessman, and he's purporting to have an investment project. And he is saying, give me some money to invest in this project, this specific project. There's no discretion there. This is an arm's length commercial transaction. He gives someone a note and says, I'll pay you back 10%, and then he doesn't do that. That, I think, is a little bit different from this case. That's the Mullins case, and then in the Second Circuit, the Jolly case. And this court made that distinction in Kaplinger, where, you know, on one hand, you have Bolin, where someone represents themselves to be a traitor and takes money and uses their position as a purported traitor to say that they will invest the money, and they have discretion in that case. On the other hand, you have Mullins and you have Jolly in the Second Circuit, where it's more of an arm's length commercial transaction where someone is just lying and saying, you know, I have this project, you should invest in it, it's a great deal, but then they take the money. It's a fine distinction, but I do think it is a distinction.
So in Judge Richardson's example of the law clerk who takes the money and runs instead of paying the water bill, where does that fall on that continuum?
I think that probably falls a bit closer to the Mullins side. It's fraud. It's certainly fraud. But it really depends on the facts of, you know, what the relationship
So
is.
I thought the difference would be, so when I say, Jim, here's money, go pay it, right? He goes down and he pays it. So in that instance, it's not an arm's length transaction, right? He is like serving as my agent. If in contrast, I say, hey, Jim, come mow my lawn, here's $100 for doing so, and he doesn't mow the lawn, well, that might be fraud, right? But it's an arm's length transaction, right? I
Yes.
paid him to do something. In the country club example, what we've said is, give me a loan, right, so that I can build this business up. We write out a promissory note, I hand it back, I get the money. That's an arm's length transaction, just like paying Jim to cut the grass, right? I paid somebody for a loan, I've gotten a promissory note back, right? That's not a position of trust any more than I've got a position of trust with my Bank of America, right? Like that's, to me, those are like the fundamental distinctions. Like one is an arm's length transaction, and one, Jim is actually serving as my agent, right, to go carry out a given task.
Yes, I think Your Honor has obviously very well articulated the distinction. And there is an element of what is the relationship between the actors. In Mullins, these were just, you know, people he knew from the country club, but they weren't, you know, close friends, or there wasn't any agency relationship or any personal friendship. But in this case, Mr. Brewer did gain the trust of, you know, friends and friends of friends, and used his position as, or his purported position as an investment advisor, a broker, to betray their trust. And I would point out
How much
that,
in this kind of a situation do we just trust the district judge?
I think you do, and that's why we believe the proper standard of review is clear error here, because the district court heard all the evidence at sentencing. It heard the testimony of the agent who investigated the case. It heard from at least two victims. It had the government's sentencing memo. It had evidence that he held himself out as a broker, a trader. He was a day trader. He said he had access to margin, an account that other people didn't have. He said he only took clients with a minimum of $25,000 to invest. That's at JA 189. He, you know, and after, I do want to stress what the court said. After hearing all this evidence, Judge Cogburn said they put their trust in him as a reported broker, a day trader. So he found that, you know, specifically found that Mr. Brewer had represented himself to be a broker and a trader. And it doesn't matter that he didn't say, I'm a licensed broker with Vanguard, or you know, something to that effect. He purposefully created the impression that he was a broker, a trader, somebody that these people could trust, and they trusted him, and he betrayed that trust. So we do believe that the district court did not clearly err. It's well supported by the evidence at the sentencing hearing, and you know, this court should affirm because it's plausible in light of the record.
Can I ask about this issue of discretion? I thought I heard your colleague on the other side. She said two things. One, it's the government's burden to show that Mr. Brewer had discretion, and second, that there was no such evidence in the record. What's your view of that?
So we pointed to the lack of evidence in the record that they limited his discretion in any way, and that's because we're on review here. So we're looking at the entire record to see if the district court's finding was plausible in light of the record. Mr. Brewer did cite to certain stocks, but there's nothing in the record that says any of his clients or his victims told him invest $50 in Apple and $60 in Tesla, that they directed his investments in any way. There's no evidence of that. And there is evidence that, the agent went through every single victim at the sentencing hearing and said, she gave him money to invest in the stock market. He gave him money to invest in the stock market. The district court's finding was certainly the inference that he made, that these victims gave Brewer discretion to invest as he saw fit, was certainly plausible in light of all of that evidence.
As I understand the government's position, even if that were true, that they had limited his discretion in that way, that given the principal-agent relationship, that even with that limitation, it still might be appropriate to apply the enhancement.
Because this is a case where we're looking at someone who represented himself as a broker, which is a position of trust, yes, I do believe even if they limited his discretion in some way, that it would still be appropriate, but we don't think that they actually did.
Do you have anything else, Ms. Wood?
If the court has no further questions, we will rest on our briefs and ask that you affirm.
Thank you very much.
Thank you.
Thank you, Your Honors. Addressing quickly, Syker, as was noted earlier, in that case, we were looking at an individual who was the sole employee of a surgeon, and there was an issue with how the funds were being handled by, she was, I believe, in a secretarial position, and there the court found that because she was given significant discretion over those funds, that the enhancement should apply. And what I'd like to address briefly, Your Honors, based on the government's argument, is that there was this discussion of even if it was minimal discretion, that isn't the exact words the government used, but that would be sufficient. That's a misrepresentation of the case law. When we look at United States versus Kaplinger, and I also believe United States versus Bolin, the court is looking for broad discretion. And the language within the guidelines in Note 1, it is also described as professional or managerial discretion that is, for example, substantial discretionary judgment that is ordinarily given considerable deference. And so while United States versus Brack says there doesn't need to be complete discretion, there still needs to be something more than minimal discretion. So even the only thing in this record that describes the sort of transactions that were expected by the investors is that he would invest the money in either a particular stock, including Apple, Tesla, Amazon, and Moderna, or a cannabis store. And so that's how limited this record is in terms of evidence of discretion. And even if we were to allow, which I argue it is not, but even if that is minimal discretion, that does not meet the requirements under this court's precedent. Additionally, I'd like to address the standard of review. The government argues that the standard of review is clear error in this case. We submit the court should apply de novo review because this is a legal question of what qualifies as an abuse of trust. Clear error is something the court should apply when there's a dispute of fact. Here, there are no disputed facts. The only fact that was found below is that Mr. Brewer, or the investors believed him, but that's not determinative based on the analysis that's required under the factors that I've gone over with the court. Regardless, though, Your Honors, this court could address this case as it did in United States versus Behringer, and it doesn't need to reach the standard of review here because under either standard, it's our position that we would prevail. Because the district court didn't meaningfully analyze whether Mr. Brewer was pretending to act in a fiduciary fashion, and it isn't plausible on this record that for the court to conclude that this guideline should apply to him. Because again, as Your Honor pointed out with the government, there is no evidence of the required discretion. And I'd point the court to all the cases involving an individual that was acting in the role of an investment broker, financial advisor. What is consistent between those cases is that the defendant there was given broad, substantial, significant discretion over the funds, of which we don't have here. Unless there's any further questions, Your Honors, we'd ask for the court to reverse and remand for resentencing.
Thank you very much.
Thank
Ms.
you.
Torrey. I want to thank both counsel for their fine arguments this morning. We'll come down and greet you and move on to our final case. The final case is 24-1900, Doe versus Mast. Mr. Moran.
Good morning, Your Honors. Chief Judge Diaz, Judge King, and Judge Richardson. May it please the court. John Moran of McGuire Woods. On behalf of appellants, I've asked to reserve 5 minutes for rebuttal. Under the First Amendment, a court may not impose a prior restraint on a litigant's extrajudicial statements without satisfying strict scrutiny. That is, without determining that the speech restriction is necessary and narrowly tailored to serve a compelling government interest. The district court erred in refusing to lift the ex parte speech restrictions at issue based on that court's conclusion that plaintiffs could sue pseudonymously under the standard this court articulated in James versus Jacobson. The court should therefore reverse the decision below and remand with instructions for the district court to vacate the portion of the ex parte protective order that restricts the Mast and their attorneys and agents from, quote, disclosing any information that directly or indirectly identifies plaintiffs or their family members to any person. Now, I know we have a lot of ground to cover, including some jurisdictional issues that were carried over from a motion to dismiss. There are 3 points that I would like to emphasize today during my argument, 2 that are legal and 1 that's factual.
What's your best argument for jurisdiction?
So, Your Honor, as the Sixth Circuit recognized in Ford, there are 3 different ways that courts of appeals have exercised jurisdiction to review. We think the best one and the most straightforward is under 28 U.S.C. 1292A1. That this is
an injunction?
An appeal of an order refusing to dissolve an injunction. That as the Second Circuit has held, that a protective order, to the extent that it purports to restrict a litigant's out-of-court statements, is in the nature of an injunction, and therefore an order refusing to dissolve that portion of the protective order would be appealable under 1292A1. Other courts have exercised review under the Cohen collateral order doctrine, or alternatively under a writ of mandamus. We think any of those avenues could get the court to appellate jurisdiction, but we think 1292A1 is the correct one and the most straightforward. If I may, the 2 legal points are, 1, that there's a critical material difference between a court's
I'm sorry to
order.
interrupt you, but before you get to that, even if we agree with you that there's a path toward jurisdiction in this case via the collateral order doctrine, why is the appeal timely in this case?
So, Your Honor, the question would, if you're proceeding specifically under the collateral order doctrine.
I know you have another option. You say mandamus gets you there, but let's assume that that doesn't work. I mean, the order was entered long before any other judgment was entered in this case, right? So why wasn't it appealed then?
So I think, Your Honor, whether you're looking at it under 1292A1 or under Cohen, the collateral order doctrine, the question is, what is the order being appealed from? We agree that this is not a timely appeal of the September 2022 ex parte protective order. That was the original protective order that was entered in this case. It was entered before we were even served with the complaint. And so we acknowledge that there is not a timely appeal of that particular order.
But you were in the case.
Well,
Soon after that.
we were in the case soon after that. The basic timeline is that.
And you know what the provisions were of the 2022 order. And then, but your notice of appeal is in 2024.
Yes, Your Honor. So if I can unpack that a little bit, I think part of our argument is that we would take issue with knowing the material terms of the order. So the order, as I quoted, it prohibited the parties, including the mass, from disclosing any information that would directly or indirectly identify the plaintiffs. The precise contours of that and how the district court understood that order and applied that order played out over time. The specific timing is that the complaint was filed and the ex parte protective order was obtained on September 13th, 2022. The mass were then served a week later on September 20th, 2022. At that time, we agree, they did not immediately appeal the ex parte protective order. We submit that's based in part on the fact that they didn't understand and had no basis to understand the way that the court would interpret that order and apply it to restrict their out-of-court statements. In particular, following that, on October 20th, which was more than 30 days after the ex parte protective order, so after, if the clock were truly running 30 days from the order, after the order had run, the Associated Press ran a story that included on-the-record interviews, that was based on on-the-record interviews from plaintiffs and from their counsel. Further stories were published in November of 2022 and December of 2022. Then in January 2023, the mass came to the district court and said, we are seeking to lift the protective order. We think that it should not have been issued when it was issued, but we also think that even if it were properly issued when it was issued, that there have been material changes in fact, that the mere fact that the plaintiffs have given interviews to the media, through both directly and through their counsel, undermines their claim that they are at risk of having their identity disclosed and that they need a coercive judicial order to restrict the mass ability to speak and identify them either directly or indirectly. And so that was the time when we sought to lift the order. It was then over a year and a half later before Judge Moon ruled on the order, which he had by that point combined with 2 contempt motions that plaintiffs had filed in the intervening year and a half. So we agree that we did not file a timely appeal within 30 days of the September 2022 order. I respectfully submit the court should consider that if it were to hold that that was what we were required to do, then the court might see a lot of premature appeals.
But it's also fair to say that you can't now raise, and this is perhaps why you have not raised, arguments with respect to the irregularities with that order. So that order was issued ex parte. We don't typically allow prior restraints to be issued ex parte, but that's a procedural issue that you now can't raise because that's not a problem with respect to the order that you've appealed.
Correct, Your Honor. We acknowledge that our appeal now lives and dies with the issues that are encompassed within the scope of the August 2024 order. We think the key point, plaintiffs cite a few cases, including the FTC case, that stand for the proposition that when a later order merely sort of executes on or reaffirms an earlier order, that they effectively merge together. So there is no later order that can be appealed independently of the first order. And we think that doctrine simply doesn't apply here because it's a different holding. It involves a definition and expansion of the material terms of the protective order, and probably most fundamentally, it was decided on a different factual record than the ex parte order that was entered in September 2022. If the court,
No,
I'm of course happy to answer
give me the
court's
3
question.
points you want to make quickly, because then
Sure.
I got a different question.
So the 2 legal points are these. One, there's a critical legal difference between a court's authorization of pseudonymous litigation, which fundamentally implicates the court's control of its own docket and the judicial machinery on the one hand, and a court's order restricting the out-of-court statements made by a litigant, which implicate fundamental free speech protections that belong to those litigants. So we fundamentally reject, and we don't think there's any precedent supporting plaintiff's contention that a speech restriction, a gag order, however you want to characterize it, that a limitation on out-of-court statements is a necessary corollary of authorizing pseudonymous litigation. The second point is similar, that there's a critical difference between a court's restricting the disclosure of information that a litigant obtains through the judicial process So for example, discovery that's produced under a judicial protective order or disclosure of the contents of a sealed filing on the one hand, and on the other hand, a court's restriction of on the disclosure of information that a litigant possesses independent of the judicial process. And it's undisputed that the content of the communications that are now clearly construed by plaintiffs and were construed by the district court in the August 2024 order, the content of the statements that was construed to be impermissible identification was all information that was known to the mass well before this litigation was ever filed. And that leads to the third factual point. It's the unusual and remarkable context in which this arises here, where at the same time that the plaintiffs were seeking an order authorizing them to proceed under pseudonyms and to restrict their disclosure, they were giving...
You're talking about in 2022?
Yes, sir, in 2022.
Okay.
At the same time that they were seeking the protection of pseudonymous litigation and a restriction on the mass out-of-court
Which was
statements.
immediately on filing the complaint?
Yes, Your Honor, the ex parte protective order was sought contemporaneously with the
That's
plaintiff.
when you do that, when you file the complaint, you want to proceed as a doe. That's what, if you're going to proceed as a doe, you've got to get it protected immediately.
Yes, Your Honor, we're not challenging.
That way, that's the way it works. Yeah, but you're talking about it now. I mean, you're giving us the background of it. Go ahead.
Okay. We consider it, I personally consider it remarkable in my experience that to have an order restricting out-of-court statements in a context where the very party that sought those restrictions is giving media interviews in order to further a public media scrutiny of their case that is designed to tilt public and
I can't
judicial.
hold back anymore. All right, so, I gave you all.
Understood.
All right, so you sort of start with this premise that prior restraints, except hypothetically that I believe this is a prior restraint, you start with the premise that prior restraints are subject only to strict scrutiny. And I read the case law from the Supreme Court to say that prior restraints are actually more restrictive than strict scrutiny, that in fact they have a more searching inquiry and that they're a set of, as the Supreme Court says, narrowly defined exceptions for which we permit prior restraints. So it's not some freewheeling strict scrutiny, to the extent we call strict scrutiny freewheeling. It's actually more limited than that, right? That in fact the Supreme Court has identified only 4 grounds that will permit a prior restraint. You can talk about obscenity, and but the point being, do you agree that those cases like Southeast Promotions and the like limit what we're doing? Like if it's about a fair trial, then you do strict scrutiny. If it's about national security, then you do strict scrutiny. If it's about obscenity, right, then you do strict scrutiny. But we have to go through that threshold question first.
Well, if I understand the court's question, then the point would be that other prior restraints outside of those categories would just be categorically unconstitutional.
Absolutely.
And even a finding of strict scrutiny wouldn't justify
Absolutely.
them. I mean, we would certainly welcome that rule. I think reading Murphy Brown,
Well, but Murphy Brown's easy, right? Because Murphy Brown is one of the very exceptions the court has identified, right? Because the right to a fair trial is one of the 4 narrow exceptions that the Supreme Court has recognized that permit these types of prior restraints. So, of course, it makes sense for Murphy Brown to do strict scrutiny because it falls within one of the 4 exceptions, right? But Southeast Promotion says that it must fall with one of these narrowly defined exceptions, and there are 4 of them. Now, this case might fall into one of them too. I can have that discussion. But at this threshold question, I guess I wonder why we're not running it through that lens first. And then when we get to strict scrutiny, we might have the same kinds of arguments.
yes, Your Honor, I mean, we made a choice not to argue that if there were a genuine concern about the protection and safety of the plaintiffs and their family, and we don't think they've ever been put to the factual test, we proffered evidence that would have rebutted their evidence and weren't afforded the opportunity to put it on, and we'd be happy for that opportunity to do so. So we've chosen not to contest that could justify a restriction if it satisfied strict scrutiny. That may not be the right doctrinal answer at the end of the day, but...
And that's what Judge Moon relied on.
which
That's
yes, Your Honor.
that's the basis of Judge Moon's.
The interest that he said
Position.
justified the order was to protect the plaintiffs and their family. And that, we think, for what it's worth, that's another example that distinguishes the September 2022 order from the August 2024 order, which is that one of the stated bases for seeking the order in 2022 was the plaintiff's concern that if and when they returned to Afghanistan, that they would be subjected to harassment and threats based on their participation in this litigation. In the interim, plaintiffs obtained asylum and have disavowed any intention ever to return to Afghanistan. And so that factual basis, which was part and parcel of the September 2022 order, did not exist at the time of the August 2024
Can I ask you a
order.
question about the nature of this order, and specifically, how is this order, which essentially does limit your client's ability to, remove the pseudonyms that otherwise would apply to these particular parties, any different from a traditional protective order involving confidential information and, for example, a trade secrets case?
Sure, Your Honor. I see I'm running low on time, but the fundamental distinction is that this is a restriction on the disclosure of information that was not obtained through litigation. And so Professor Volokh talks about this in the article that we cite in our brief, and we think it's borne out in distinguishing some of the cases that plaintiffs...
Why does that matter legally?
It matters legally because we think it's okay under the First Amendment for the court to say that we're going to condition a litigant's access to information that it's obtaining through the judicial process on an agreement as to how it's going to use that information. So the court can say, just like a private party could say, I'm willing to tell you something, but you first have to agree that you're not going to use it for X, Y, and Z purposes. And so the court can say, we're going to coerce the other side to turn over these documents to you, but you have to agree that you're going to use them only for purposes of this litigation. What the court doesn't have the authority to do is say, we just met these plaintiffs yesterday. We understand that you have this long-running factual dispute that's playing out in the media, and we're going to stop it now. We're going to let them continue talking, but we're not going to let you talk anymore.
Well, that's a little bit unfair, right? You can talk all you want about it. Your clients were free to talk all they wanted to about the merits of the case. They just couldn't identify these particular parties in the context of whatever interviews or statements they wish to make.
Well, with respect, Your Honor, we think that the identity of the parties is inextricably wrapped up in the merits of this case. It is fundamentally a dispute about their claim to be familiar relations of the child, which is a factually, hotly contested and disputed issue.
Not in this court, though, I guess.
Not in this court. This is an ancillary issue, which is why we think Cohen is one of the available doctrines under which this court could exercise jurisdiction.
All right, thank you very much. Mr. Ellifer, could you start with that last point about your colleague's view that this is somehow fundamentally different than a traditional protective order in a civil case? You might disagree with that. If so, tell me why.
I thank you. May it please the court. Kevin Elliker on behalf of John and Jane Doe. We do disagree with that point, Judge Diaz. We pointed the court in the briefs, and the masts notably don't mention at all the Seattle Times case from the Supreme Court, which dealt with whether First Amendment scrutiny applies to a protective order that has the effect of restraining speech.
But involved exactly as your colleague just explained, like information that was obtained during the course of litigation. Like if Mr. Moran was going to cite a case to prove his point, I thought he was going to tell us Seattle Times.
Sure, and he didn't, but I would say I have two responses to that. The first is, as I think Judge Diaz's hypothetical earlier about trade secrets is a good example. I think it's not always the case that a protective order that may be lawfully entered can only apply to information that's gained during the course of litigation.
Oh, no, but nobody's saying it's only, right? The question is, it's then a prior restraint, and you've got to satisfy strict scrutiny. Nobody's saying that you can never do it, right? The question is, what is the test, right? And Seattle Times tells us it's like a good cause test where it's information that's inside of the discovery process, because indeed the government has compelled through the judicial process you to turn that information over. But where it's not, where that information is instead sort of known independent of the judicial process, then that is like a fundamental prior restraint.
Well, Your Honor, on that gets to my second point. On the getting the information only pursuant to it having been part of the judicial process. What the protective order in this case actually prohibits is the disclosure of the plaintiff's identities, capital P plaintiffs in this case. As Judge Moon mentioned in his decision below, the prohibition is on identifying plaintiffs as such, plaintiffs in this case. This is not a circumstance of prohibiting, hey.
Okay, so your view is, and if you concede this, this is helpful, right? So if the mass here went to the newspaper, like your clients did, and said, we are telling you, we are not talking about the litigation, but we adopted this baby, just purely factually, we adopted this baby, the baby's name is whatever the baby's name is, and this other couple named Jane and Bob, whoever they are, they took the baby from us. And we've made no comment with respect to any litigation, and we don't tell you that those are the people that are involved in the litigation. You would plainly show up and say that they violated this protective order.
Well, Your Honor, I think we would, because
Of course you would.
well, that to me strikes me as a wink, wink, nod, nod. We're not telling you who the plaintiffs are in this case. We're not talking about the litigation,
But then you're doing is you're telling them that they cannot talk about facts that were known to them before your clients invoked the judicial process, before you came to federal court and said, federal court, give me relief. And in doing so, you're saying this other group of people, they cannot talk about the things that occurred prior to that lawsuit, right? Because you have ordered that they can't use the names, and the names are obviously like part of the story.
well, Your Honor, I guess the question that I would ask on whether.
And when your clients told the story to the newspaper, they used their names.
Well, Your Honor, our clients did give interviews on condition of anonymity, which was honored.
Not anonymity of the other side, just your own anonymity. You say, please don't use my name, that's fine, but you go tell your story to the New York Times or whoever it was, which, you know, you've got, at least without a protective order, every right to do. But that seems like a hard line to draw, is to tell us that they now can't talk about the things that occurred before the litigation even began.
Your Honor, I fundamentally disagree with the characterization of they can't talk about the things that happened before the litigation.
They're limited by it, so they're restrained from talking about parts of what happened. They can't use the names.
Yes, to the extent you want to say names are part of what happened, they are restricted from identifying the plaintiffs. But they could have, I'll give you an example. They could have done everything that they did in the CBS Mornings interview, or everything that they did in the event that Judge Moon actually found them in contempt on, which was to go off and do fundraising for the purpose of this litigation and to have his brother go be his agent, be on the One American News Network to talk about this case. Could have done all of those things, just don't show an identifying photograph. I think that our case is fundamentally much more challenging in a potential contempt proceeding if they had just not shown the photograph. This is not a case about whether the masks can go and tell their side of the story, about whether they can go and raise money for a legal defense. It is simply about protecting the identities of our clients because Judge Moon made factual findings that are not challenged.
And they may, what I'm trying to rub though is like not whether that's a permissible thing to do, right? It might be, right? What I'm getting at is that this is, back to the Chief's question, this is a restraint on them talking about things that they know independent of the judicial process. And then we've got to ask, is that okay? And that is a fundamentally different question than what Seattle Times tells us applies on the trade secrets or information developed during, the judicial proceeding. I totally understand, and you might well be right at the end of the day. I'm not actually fighting you on this, that you can establish a compelling interest and that you can establish narrow tailoring. That may well be true. My point is you can't say that it is Seattle Times because this is all information that was known to them before that they would have a First Amendment right to talk about without judicial intervention.
Just to follow up on that, can you talk about whether or not in Seattle Times that requirement that the information is learned during litigation, was that an absolute condition, or was that just a statement made in the course of the court's holding?
I think that it was not stated as a condition of this rule only applies here, but I think it was, they were deciding under the circumstances of that particular case. So Judge Richardson, I take your point. I understand. The language that Justice Powell wrote in Seattle Times mentions that it uses as justification that this is information,
But
that they
that's
only
not the
get.
complete set, I don't think, of examples where, a protective order might be in order.
That's correct, and that gets me back
Pardon
to.
the duplication, but.
Yeah, I understand.
Go
Well, and the point I was making, in response to Judge Richardson, I said I had 2 points, and I got to my second point. The first point is, for example, in trade secrets litigation, Company 1 sues Company 2 for stealing a trade secret. Company 2 already knows what the alleged trade secret is before the litigation was filed. They didn't learn it by virtue of the litigation. But that doesn't mean that a protective order can't prohibit the parties from disclosing that information.
Generally speaking, in a trade secret case, like, the other side doesn't know the actual, like, details of the trade secret, right? That's sort of the point. You don't know what the, special sauce is. And that's what the protective order is over, is you learning about the special sauce.
Well,
Right? I mean, that's what, you get discovery, so you get to see the documents, the financial records, right? Whatever you want to say, it's not the things that you knew before.
Well, Your Honor, there may be a dispute where Company 2 doesn't think it's a trade secret, right? And Company 1 wants to make sure that it is. I mean, like, you could have these circumstances where there's information both sides know that one has good reason to keep from being public in the course of litigation.
Well, and if the other side chooses to publicize something that might be a trade secret, they may well bear the brunt of having done so. But if they knew it before, they have to, it seems like to me that, our case in Murphy Brown, consistent with Seattle Times, they got to establish strict scrutiny to do that.
Well, and Your Honor, I think that brings me back to sort of early this morning in one of the earlier cases, you asked an advocate, what really matters? What are we talking about in this particular case? I'm not suggesting that what you're pointing out doesn't matter. It's very important.
You are, but that's okay.
No. What I
I'm
want.
used to it, I can tell you.
No, Judge, I genuinely, what I want to do is take a step back and say, here's something else that matters. Something else that matters is the effect of the argument that the Masts are making, which is they're not challenging James versus Jacobson. They're not challenging John and Jane Doe's ability to be John and Jane Doe. They don't challenge Judge Moon's factual findings regarding the risk of harm to them or to their family members. I heard Mr. Moran say he didn't have an opportunity to present evidence. I think that's news to me. If you look at the record at page JA 160, does the defendant plan on calling any witnesses? Mr. Moran, Your Honor, Joshua Mast and Jonathan Mast are here. We won't call them unless the court expresses an interest in hearing from them. Everyone had an opportunity to put evidence into the record. What I am trying to emphasize here is, what they're insisting on is, notwithstanding a completely lawful and legitimate basis to be John and Jane Doe in court, the defendants have a right to go on the courthouse steps and tell everyone who John and Jane Doe is. That's not something that you can pull out logically from James versus Jacobson, from any of the Doe cases that this court has decided. Doe versus Sidar was in 2024.
None of those cases address that question, right? Like, that's not what those cases are addressing, right? They're addressing the judicial process, right? Because when we put something on the web, we are putting it out there. That's the court system putting it out there, right? And our right to speak looks very different, right? But the access to that is a different calculus. But this is a private party who's being told prior restraint on their speech about things that they otherwise knew. I mean, those are not the questions that are coming up in the pseudonym litigation that we do have before us, right? Those are just fundamentally different questions under the First Amendment. And it looks to me an awful lot like Murphy Brown. We've got a prior restraint. It's a gag order.
Your Honor,
you might think gag orders are great. And listen, I've been involved in cases where they had them. And I think in those cases, particularly where there are high-profile issues, this right to protect a fair trial often will justify, or at least sometimes will justify, the use of these gag orders, particularly when they're narrowly focused on the lawyers or the parties that are involved. I totally get that. But that requires that extra step. It's not just the same as calling somebody Jane Doe.
I understand the sentiment, Judge. I understand Murphy Brown very well. I wrote the briefs in that case, and our firm won that case. We are not in favor of gag orders. That's a fundamentally different case. I do want.
Help me understand. Give me just your like 3 bullet points. I'm confident that you have them, as to why you think this is not Murphy Brown.
Well, because the restriction is quite narrow. I think that
Which restriction?
The restriction in this case is quite narrow. If you look at the gag order in Murphy Brown.
But why does the extent of the restriction, right, might go to narrowly tailoring, right, but it doesn't affect whether it's a prior restraint, right? If I restrain you from saying one sentence or I restrain you from selling your book, like, it doesn't make a difference that I just took a little bit of your First Amendment right? Right? I mean, that's not a distinction that we ever rely on in the First Amendment context, is it?
No, well, Your Honor, so then assuming then that we're going through the First Amendment strict scrutiny analysis, one of the ways this is fundamentally different from Murphy Brown is how that was a blanket catch-all restriction, no discussion about any of the case to any communications media directly, et cetera, et cetera, et cetera.
Totally fair. I guess maybe I should be more precise. Why is this not like Murphy Brown for requiring that we do this strict scrutiny as a prior restraint?
Your Honor, I think what I can tell you is our position is it's not like Murphy Brown because this is an order that's entered under the auspices of a protective order that through the court's power to show good cause to protect the parties, that good cause standard exists both at Rule 26, both Rule 5.2.
But why didn't that same argument then prevail in Murphy Brown? Like, that's what I don't get. Like, if you're right about that, which maybe you are, then Murphy Brown's wrong. And, you know, our en banc court can do that. But what we can't do, and I totally understand your argument, right? Murphy Brown might have been wrong, right? But we're bound by it, right?
I don't think Murphy Brown was wrong.
But then tell me why Murphy Brown doesn't require that we do strict scrutiny. We might get to a totally different answer.
Right.
I understand those distinctions on the back end. I'll stop with this question, but just give me, if you have a reason why Murphy Brown doesn't require that we do the strict scrutiny, and in other words, that the district court got its first holding totally wrong.
Right. My reason is Seattle Times. This court in 2011 cited Seattle Times, ACLU versus Holder, saying good cause under the federal rules of civil procedure does not require heightened First Amendment
Can I
scrutiny.
ask you a question about Murphy Brown? And,
Yes.
So was there a fight about whether or not the information in that case amounted to a gag order, or was the fight about the scrutiny, that whether strict scrutiny was overcome in that case?
There was not, the fight in that case was about the necessity of the order.
Right, so there was an assumption that it was a gag order. The only question was whether or not it was needed, right?
Right.
The issue in this case is whether or not you think the scope of this order rises to the level of that particular type of gag order in Murphy Brown. And, you know, that wouldn't necessarily require us to overrule Murphy Brown, would it?
No, of course not.
And just so I'm clear, will you tell me why in Murphy Brown we take it to be an assumption, not a holding, that this is a gag order? I mean, it describes it as a gag order, right? A gag order imposing stringent restrictions on participants in a series of suits. I mean, it seems like to me that's not an assumption. It could say, assuming this is a gag order, this is what we would do. But it actually says it is a gag order, and then it says it is then analyzed under strict scrutiny.
Right,
I don't
and
understand that.
I'm not disputing that was the holding of that case. The question is whether this order, in this case, amounts to a gag order.
That's right. And Your Honor, I think I would say that there was no dispute in Murphy Brown about the characterization of the order as a gag order.
And I guess I'll stop after this one, I promise. Can you tell me the reason why that was a gag order subject to strict scrutiny and this order is not? What distinguishes this order such that Murphy Brown doesn't require us to do strict scrutiny? And you've danced around that, but I'm still waiting on the answer to what about this order takes it outside of Murphy Brown? For the purpose of finding that we have to do strict scrutiny. We can talk all about how you meet strict scrutiny. I'm literally just trying to get the framework right.
Sure, and Your Honor, I think that what we're talking about is a distinction between a gag order and protective order. I don't mean that semantically, that the judge called it one and so it's not the other, but that's how the case laws describe them. Judge Wilkinson's opinion in Murphy Brown talks about gag orders and other cases
Is there
involving gag
any
orders.
other reason than the name that's used?
It's
Do you
not-
have a substantive distinction between what this order requires and what that order requires?
Your Honor, it's through the court. I say the gag order is entered pursuant to the court's inherent authority to control the proceedings in front of it. That's one distinction. Here, this was not subject to the court's inherent authority. This is subject to the rules that allow the court to provide protection, Rule 26, Rule 5.2. That's where the good cause standard comes from, and that's the hook to Seattle.
But there's no difference, you haven't given a difference with respect, and I'll stop after this one, I promise. There is no distinction between what that gag order did, or what that order did, forget its title, and what this order does with respect to the restraint on speech. It might have a different inherent authority, I don't even understand what that even means, but whatever, I'll grant you everything you've said, but the effect of the order is the same with respect to the restriction on speech.
I think for that, in this narrow issue here, yes. If I could very briefly talk about the jurisdictional issues. The question was raised earlier about the timeliness issue, the suggestion that how could this have been appealed? I think Ms. Moran got the dates a little wrong. The masks appeared on September 20th. They were served on September 6th. But in all events, the federal rules of civil procedure say that a lack of notice doesn't extend the deadline for a notice of appeal. That's Federal Rule 77D2. By my read of the rules, I think they had two options. Option one, move after you've appeared, but while you're still within the notice of appeal time period, which they were when they showed up in court, ask Judge Moon to extend that deadline, and by that 30 days, that's under Appellate Rule 4A5. And during that time period, could have asked
Can I
him.
ask a question? Is it your view that a court can enter an ex parte prior restraint? Is that something that a court is entitled to do?
Well, no, Your Honor, but I don't want to go back around over and over again on the prior
They
restraint
haven't
piece.
challenged it because they didn't appeal that order, but it seems a little odd to say that, like, the district court did something that I think we all sort of acknowledge, like, was not procedurally proper, and they show up after the game, and then now when they show up to challenge this and change circumstances, the argument is they needed to challenge this ex parte restraining order.
We don't all agree that the judge did something procedurally improper. The only
You think
way,
they could do this ex parte?
it's the only way that John and Jane Doe can be John and Jane Doe.
Well, the only way they can proceed pseudonymously,
Right.
right? Whether there's a prior restraint is a separate question, right? They're not challenging proceeding pseudonymously. They're just challenging the prior restraint. Those
Well-
are not the same. You acknowledge those are not the same, right?
Well, Your Honor, I think that Judge Moon had a very salient point, which is that in many ways, what you're calling a prior restraint, what we're calling this protection of our clients' identities, is a corollary to being pseudonymous in court. I understand you disagree. I understand. But that's our position on that particular issue. The question of there being new circumstances, they certainly didn't present evidence of new circumstances. Judge Moon made a point several times in his decision.
Did they put in the newspaper articles about your client going and speaking?
That information was in the record,
That
but
was new, right?
Well,
It was in the record.
the information, though, that the masks pointed to below, and Chief Judge, I see my time has expired. If
You
I
can
can.
continue.
So what they pointed to was the suggestion of the hardship that the protective order was imposing on them. And that was what Judge Moon said was speculative and underdeveloped. He said several times, they have made arguments but have not put forward evidence. But regardless, Judge, even if they brought forward new evidence, the issue with that is, from a jurisdictional, timeliness of the appeal standpoint, is that suggesting that anytime there's an order that settles some issue, and then there's new evidence that comes up, and the court just denies it because it says this new evidence wasn't sufficient enough for me to change my mind, you're reopening the appeal clock. And that's not what is permitted. What you look at is, did the second order alter or change the rights that the
We've
first
said
order?
this
By the second order, you mean the 2024 order?
Yes,
That's right. In the earlier, when you were talking about 2022,
yes.
and they missed the timing, you say you're taking position in 2022, and that wasn't saved by the 2024.
Yes, because the 2024 order doesn't do anything to change the rights or obligations of the parties.
Well,
If
they
you
say
want-
they can recast it and call it an injunction. And then they start running again, or modifying an injunction for an interlocutory appeal. They said that's their best argument, that it's timely, that they have a timely notice of appeal.
Yeah, and Your Honor, we think it's not an injunction. An injunction, to me, is an order that a court enters that's going to granting relief that's being sought on the merits of the case. That's why when you give an injunction, you're asking what's the likelihood of success on the merits. This is an issue that doesn't touch on the merits. The Gulfstream Aerospace from the Supreme Court says orders that relate only to conduct or progress of litigation before the court are not injunctions. I believe it was Judge Duncan wrote in the Lutz decision before this court, Congress did not envision that every interlocutory order restraining a party's actions.
So your position is it's not an injunction?
It is not.
They also say then, as a fallback position, it's a collateral order. They can appeal under the collateral order doctrine.
And it's not that either, Judge, because the collateral order doctrine has to apply categorically to an entire class of cases. If what they're, this doesn't apply categorically, because what they're trying to say is that the grant of these protections must be appealable immediately in every instance. And what you have then there is you're basically making any order entered under James versus Jacobson immediately appealable. We already know from James versus Jacobson that the denial of anonymity is immediately appealable. There is no case that this court has written that says the other way around. And in fact,
They're not appealing a pseudonym, right? That's not what they're appealing a prior restraint. I understand you disagree, but hypothetically, if I'm right that it's a prior restraint, just accept that, then they gotta be able to appeal it, right?
that's not the argument they made in their brief, Judge. What they argued in their brief was collateral order doctrine because of James versus Jacobson. That's what they said in
Well,
there.
no, but this is back to the injunction point, right? Like, if it's a prior restraint, then it is an injunction, or the denial of vacating an injunction.
Well, Your Honor.
Can I ask we disagree on the premise, it's totally fine. Can I just ask one question, which I could probably figure out, but I was curious about? What's going on in the Commonwealth Court? Where is that? And is there some hope of that sort of providing broader guidance to the parties here?
Your Honor, the case was decided, the custody battle was argued at the Supreme Court of Virginia in February, and the parties are waiting on a decision. And that goes to the lawfulness of the underlying adoption order. I don't think that the outcome of that is necessarily going to provide particular guidance to the federal litigation.
Not here, but maybe to Judge Moon.
Potentially, but I think it remains to be seen.
Can I follow up on Judge Richardson's question? Assume again that this is a prior restraint, and I know you dispute that, and would be appealable. So when would the appeal have to have been taken in this case, if that were the case?
I think when the restraint was put into place.
And so the appeal is nonetheless untimely, right?
Correct.
So then then the alternative remedy is mandamus, and tell me why that wouldn't apply here.
Well, I think then we get, if we're through all of that,
Right.
and assume everything we've talked about for the last 15 minutes, I think then we're talking about whether it survives strict scrutiny. And we think it does survive strict scrutiny. I don't think there's any meaningful dispute that there is a
No,
compelling.
actually, the question I'm asking is whether we should issue the writ in this circumstance. And I guess maybe we have to look at the merits, right? So that's your point.
I think that's right. I mean, I think the point I will credit my friend Mr. Moran with in the briefing on the motion to dismiss is when you get around to talking about what is mandamus jurisdiction. It's kind of hard to talk about mandamus jurisdiction in a vacuum separate from the merits of what you're seeking. And so I do think at that point you more or less are looking at the merits of that First Amendment issue. But again, I don't think there's a meaningful dispute to there being a compelling interest here. Again, the factual findings the same factual findings that underlie the pseudonymity order also underlie the compelling interest in, if you're going to call it a prior restraint, making sure that the does are not identified publicly. Judge Moon said that it is anything but speculative that that revealing the identities of the does publicly would pose a substantial risk of harm to innocent non-parties. As far as the narrow tailoring goes, again, we're talking only about the limited restriction on identifying John and Jane Doe. It identifies information, that information is specifically connected to the identified risk of harm, and it still provides an opportunity for the mast to disclose that information through the use of the non-disclosure agreement provision. And the last thing I'll say, you've been very generous by letting me go over time. The masts say that Judge Moon impermissibly shifted the burden to them. I would ask the court to look again at footnote 12, where Judge Moon did his alternative strict scrutiny holding. He actually found, he said, I find that these are not only narrowly tailored to serve their intended purpose, but constitute the least restrictive means to ensure plaintiff's safety and that of their families still in Afghanistan. That finding comes first in the footnote. Following that footnote, he then points out that notwithstanding his finding on that, the mast didn't bring him anything else to suggest that there was something else on the other side of that. There's no, to use the phrasing from the Martinez or the Ramirez-Ralupa case that they cite about strict scrutiny, there's no obvious alternatives for purposes of serving that compelling interest.
All right, thank you, Mr. Ilker.
Thank you very much.
You know, we think the fundamental distinction between a protective order and a gag order is that a protective order at most applies to the judicial process itself or to out-of-court statements that are related to the judicial process, for example, because they contain information that was only learned there. In fact, Murphy-Brown shows that that at most is an outer limit, because there the order did in fact cover information that was learned during the course of the judicial process, and yet the court nevertheless treated it as a gag order. I actually think the trade secret example is a very helpful one and one that I'd like to return to. And I think it also helps explain the Seattle Times issue. If a trade secret plaintiff wants to come in and not just get a protective order for discovery, Judge Richardson, to your point, to say, we're willing to produce some documents about our trade secrets, but we want to do it under a protective order. If they want to come in and say, we need you, court, to order the defendant to stop using our trade secrets now, before the case is decided, they don't do that by seeking a protective order under Rule 26. They do that by seeking a preliminary injunction and running the gauntlet of the winner factors and showing that they have a likelihood of success on the merits. If Rule 26 really were broad enough to say that it could justify an out-of-court injunction that restricted the out-of-court statements that were not based on the judicial process, then it would violate the Rules Enabling Act, because it would create a substantive right for a plaintiff to come into court and restrict their adversary's speech that Congress never enacted and that would be a creature solely of the rules. Of course, we don't think Rule 26 does violate the Rules Enabling Act precisely because it doesn't stretch that far. My friend on the other side, and I do say that sincerely, my friend on the other side said that this is not Murphy-Brown because the restriction is narrow. And I think, one, this brings to mind the vagueness challenge that we've made. I mean, there is a serious problem here with the vagueness of the directive not to indirectly identify the plaintiffs. And I think the instances in which the plaintiffs sought and the court addressed contempt are very instructive there. Now, to be clear, as we explained in the briefs, we are not currently appealing those contempt orders. There was a contempt finding on one of them. There was no sanction entered, and so we acknowledge that that part of the order is not appealable at this time. But we do think they're instructive and something the court can take notice of in construing the scope of the order. And Mr. Elker gave the example that, what we're trying to do here is go out on the courtroom steps and undermine the pseudonymity by disclosing the names of the plaintiffs. That's not what we're here trying to do, even though we recognize that the logical implication of our opinion is that our clients would have the right to do that. Let's look instead at what plaintiffs have actually used this order to do, the 2 times that they went to the court and sought contempt. The first one is for a media interview, when our clients went and told their side of the story, just the way that plaintiffs themselves had done, and they didn't like that, and so they went to the court to seek contempt under this ex parte protective order. And the second time was when our clients attempted to raise money to fund their legal defense, and they didn't like that either. And
when
so
you say ex parte protective order, you're talking about the one from 2022. That's what you're referring to?
Yes, Your Honor. So
When you say this order you're talking about,
yes, Your Honor.
22, you're talking?
Correct, the September 2022 order, and I appreciate Mr. Elcor's clarification of the timing. I did misspeak that we had been, the sequence is filing, service, entering of the protective order, appearance, and so I didn't mean to misstate that.
Can you respond to your colleague's argument that once you failed to appeal the initial order, which I'll call a prior restraint, that you forego any opportunity to ever appeal it again? Are there other contexts in which we've held that if you don't appeal originally, that any subsequent order you're barred from appealing? I mean, that seems like an odd rule. In the intervention motion context, we adopt the opposite rule of that. That seems like an odd rule to adopt, and I don't know what the authority for it is, but can you respond to that?
Yes, Your Honor. I know they cite one case involving an FTC order that involves an argument that essentially the second order kind of merges back into the first order and therefore isn't independently appealable, but we don't think that applies here for the reasons we explained. And in fact, Congress, I realize I'm running out of time here, but Congress said just the opposite in 28 U.S.C. 1292A1, which is to say if you are subjected to any injunction, whether it's a prior restraint on your speech or any other injunction, you not only have a right to appeal that at the time that the injunction is entered, but if at a later time the court refuses to lift or modify the injunction, then you have a new opportunity to go. Now,
if you read that as saying you only get one bite, that part of modifying or lifting the injunction is superfluous, because you could never get that done.
Absolutely, and what
Well, the
courts
statute says modifying, you're exactly right. It's issuing, 1291A1 says modifying. It covers you, if this is a modification.
Yes, Your Honor, what we saw.
Mr. Elliker said it's not a modification of what
Well, it also requires
what we're
the
dealing
refusal. It also covers the refusal as well, and so that's what we sought, and we were refused.
That refusing means the court won't issue the injunction. That we don't have that here.
Yes, Your Honor, I've always understood 1292A1 to include the refusal to modify or lift an injunction after it's entered. What the courts have done is say, we want to police the abuse of that, and so if a litigant is coming back every 6 months and trying again to say, well, will you lift the injunction now? Will you lift the injunction now? That there are doctrines in place to limit that. But if a party comes a few months after an injunction is ordered and said, Your Honor, the key facts on which this injunction were premised have fundamentally changed, and we think it deserves to be lifted, and the court says, no, we disagree, we believe that is appealable under 1292A1.
A protective order is an injunction, and so this one's appealable in 2024 as having been modified.
Yes, Your Honor, that's the approach the Second Circuit has taken by saying that to the extent a protective order, not any protective order, but to the extent a protective order restricts the out-of-court statements by a litigant,
But the fact that you interposed so many alternatives indicates you didn't have a lot of confidence in it. Because
Well, no, Your Honor.
It's also, because you said it's also a collateral order appeal, and it's a petition for a writ of mandamus. At least those two things.
Well, Your Honor, what the Sixth Circuit said.
I mean, that's good lawyer. I mean, you felt.
Well, I appreciate that, Your Honor.
You felt it right on.
But the Sixth Circuit set this out in Ford, and what they said is, the courts of appeals differ in which basis of jurisdiction they think is the right mechanism to review this type of case, but they all agree that it
We
can be.
normally review things after a final order, when the case is over with. That's what we say all the way through, and that's what the statute says, and that's what that collateral order doctrine says.
Absolutely, Your Honor, and I would say 1292A1 creates a congressionally mandated exception to that. The collateral order doctrine is a judicial gloss on what it means to be a final order, and of course, mandamus is an alternative remedy when that doesn't suit. Thank you, Your Honor.
Thank you, Mr. Moran. It's fair to say that we've seen some really good lawyering here today in all of the cases, and this is no exception. I also recognize the fact that both you, Mr. Elliker, and you, Mr. Moran, have taken on this very difficult, emotionally taxing, and fascinating case pro bono. and that's to your credit. So we thank you both for doing that and doing it so well and ably. We'll come down and greet you and adjourn for the morning.
This court stands adjourned until this afternoon. God save the United States and this honorable court.